if your jury room isn't gonna be redone, you might wanna complain, because I think Judge Cox's was, it looks fantastic. I don't know if it was different, it was already redone before his other renovations, but.
So I don't know, his jury room had a big leak in it a few years ago, so
That's
that might have
probably
been
it.
when it was redone.
It looks real nice. I was in there just 2 days ago.
Yeah, I've been told, I asked, hey, could you do the jury room as well? And the answer is not right now. There's this footprint where they do just the courtroom, but they will come back around apparently and do the jury rooms. They use the jury room to store all the computer equipment, so they can't then be in there doing that, so.
Ah,
We'll
understood.
see. All right, when we left off, we were maybe gonna take a plea with Ms. Vaughn, which is why I think Mr. Shapiro is here. And we needed to do Mr. Musa and a quick revocation, but that needed Ms. Rios, who's right there. Look at that. All right. Ms. Rios, are we ready with any of your 3 cases?
Yes, Shaquita Vaughn, we're ready to do that plea.
Okay, let's do that. Can we bring Ms. Vaughn out, please?
Afternoon, Judge.
Noon. And is this a plea to both cases or one case is gonna
Both.
be? Okay,
Both cases.
And Ms. Rios, it's non-negotiated on
Yes.
both? Okay.
Well, the death by conversion is negotiated,
For the 1 year or the 2 years?
2 years probation.
Okay.
you'll handle both. Ms.
Yes.
Nix doesn't need to do one.
Yes, Judge.
All right, 1 second here.
Yes.
Jeez.
Is sitting better for
Would you
everyone?
like to sit down?
Yeah.
Go for it.
Okay,
Not big.
sitting it is. All right, Mr. Rivers, are you ready? And we'll get on the record. This is 21SC1799011 and 23SC191989. Both cases involve Ms. Vaughn, who's here in court, along with her attorney, Ms. Rios. And we have Mr. Shapiro here for the state. Ms. Vaughn, in just a moment, Mr. Shapiro is going to put you under oath and then ask you some questions about your rights as a criminal defendant. Make sure you answer his questions truthfully and completely, but also make sure you let Ms. Rios or me know if you have any questions or if there's anything going on that you don't understand, okay? Great, and when you do answer, make sure you speak up, because Ms. Rivers needs to be able to hear you.
Okay.
All right. When you're ready, Mr. Shapiro.
All right, thank you, Judge. Ms. Vaughn, would you please raise your right hand? Do you swear or affirm that any statements or testimony that you will give in the matter now before this court will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, thank you. You can lower your hand. And Ms. Vaughn, if you want to lean into that microphone a little bit and speak up, okay? Would you begin just by stating your true and correct legal name for the record?
Shaquita Vaughn.
And are you at this time taking or under the influence of any medications, drugs, or alcohol?
No, sir.
Is there any medication that you normally take that you have not taken or been given today?
No, sir.
How old are you, Ms. Vaughn?
32.
And how far did you go in school?
In 10th grade.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
Ms. Vaughn, do you understand that you are charged in 2 separate indictments in 2 separate cases?
Yes, sir.
And do you understand that in indictment number 23SC191989, you were charged with 1 count of murder in the 2nd degree, 2 counts of homicide by vehicle in the 1st degree, 2 counts of serious injury by vehicle, and 2 counts of cruelty to children in the 2nd degree?
Yes.
And do you understand that in case number 21SC179011, you were charged with a single count of theft by conversion?
Yeah.
All right, Ms. Vaughn, do you understand that you have the right to plead either guilty or not guilty to all of those charges?
Yeah.
And you understand that if you were to plead not guilty or were to remain silent and refuse to enter any plea at all, then the state would be required to prove all of these charges against you at a jury trial. Have you had enough time to speak?
Yes.
Yes.
Oh, yes, sir.
And again, ma'am, if you'll just speak into the microphone a little louder so she can hear you.
Okay.
Okay. Have you had enough time to speak with your attorney about all of the facts and circumstances in the 2 indictments that are pending against you?
Yes, sir.
Do you need any more time to discuss the cases with your attorney?
No.
And are you satisfied with your attorney's services?
Yes.
All right, thank you, Ms. Vaughn. And Ms. Rios, are we waiving a formal reading of the indictments for purposes of the plea?
Yes.
And are we waiving any and all defects in the indictments for purposes of the plea?
I'm unaware of any defects, but I do waive for the purpose of the plea.
Okay, thank you, Ms. Rios. Now, Ms. Vaughn, has your attorney advised you of the potential minimum and maximum penalty to each offense to which you are entering a guilty plea today?
Yes.
And is it your understanding that today you are entering what is called a non-negotiated plea of guilty?
Yes.
Now, do you understand that the state can recommend a sentence to the court in exchange for your non-negotiated guilty plea, even without your having agreed to it in advance?
Yes.
And have you discussed what the state's recommendation is going to be with your attorney?
Yes.
Are you aware that in the case number ending 989 that charges you with murder in the 2nd degree, the state's recommendation is going to be that in exchange for a plea of guilty to a single count of homicide by vehicle in the 1st degree, that you be sentenced to 15 years to serve 7 in custody with the balance on probation?
Yes.
Okay. And are you also aware that the state is going to recommend a dismissal of all the remaining counts of that indictment?
After you said if I'll accept it?
Correct.
Yes, I'm aware.
And are you?
I'm gonna pause you just for a sec.
Yes,
Ms.
Judge.
Vaughn, when you say accept it, this is a non-negotiated plea, so when you are, if you plead guilty, you're not accepting the state's recommendation, but if ultimately you accept the sentence I impose, because I'm not bound by their recommendation of 15 to do 7. I'm also not bound by whatever Ms. Rios is gonna recommend. It's gonna be something less than 15 to do 7. I'm gonna make my own decision. X is gonna be my decision. If you accept that, then in fact, the state will dismiss all the other charges in the indictment.
Okay. Yes, sir.
Okay. So Ms. Vaughn, are you aware that the state is also going to recommend that as conditions of your probation, that you'll be required to submit to a substance abuse evaluation and to comply with any recommended treatment, that you will have no drugs or alcohol while on probation, and that you will not operate a motor vehicle while you are on probation?
Yes, sir.
Okay. And Ms. Vaughn, turning then to the case number ending 011, are you aware that the state is recommending a sentence of 2 years probation on that case?
Yes, sir.
And as to the case number ending in 011, is it your understanding that you're entering what's called a negotiated plea of guilty as to that single count of theft by conversion?
Yes, sir.
And you're aware again, though, that the court is not required to accept the state's recommended sentence?
Yes, sir.
And you understand that the court does have the right to sentence you to the maximum possible sentence for that charge, even though it is what we call a negotiated guilty plea as to that count?
Yes, sir.
Returning then to the indictment ending 989 that charges you with murder in the 2nd degree, you understand that the court can impose any sentence authorized by law?
Yes, sir.
And you understand that that could include a higher sentence than that is recommended by the state up to the maximum possible sentence for the charge of homicide by vehicle in the 1st degree?
Yes, sir.
And do you understand that homicide by vehicle in the 1st degree carries a potential sentencing range between 3 and 15 years in custody?
Yes, sir.
Now, do you understand that because you are at final plea today, that if the court imposes a sentence, you will have the right to withdraw your guilty plea if you choose not to accept the court's sentence?
Yes, sir.
Now, Ms. Vaughn, are you currently on probation or parole?
No, sir.
Do you understand that if the court chooses to sentence you to a term of probation, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal, while you are on probation?
Yes, sir.
And do you understand that you must follow all of the special conditions of your probation, whatever the conditions the court ultimately chooses to impose?
Yes, sir.
And do you understand that if you were to fail to follow the special conditions of your probation, that you could be subject to a revocation of your probation for the balance of your sentence?
Yes, sir.
And do you understand that because you are entering a plea of guilty to a felony offense, you would not be allowed to receive, possess, or transport a firearm in the future.
Yes, sir.
And you understand that doing so could result in a new criminal charge for which you could face a sentence between 1 and 5 years in custody.
Yes, sir.
Now, Ms. Vaughn, do you understand that by entering a plea of guilty, you're waiving any and all defenses, including any mental health defenses?
Yes, sir.
Do you understand that by pleading guilty, you are giving up a number of rights, including the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of your attorney at a trial, the right to the presumption of innocence, and the right to appeal if you were convicted of these charges at a trial?
Yes, sir.
Is it your decision to waive those rights, which means not to use them, and to enter this guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a plea of guilty?
No, sir.
And is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
All right. Ms. Vaughn, in indictment number 23SC0901689, how do you plead to the single charge of homicide by vehicle in the first degree?
Guilty.
Okay. And in indictment number 21SC179011, how do you plead to the single charge of theft by conversion?
Guilty.
Are these guilty pleas freely and voluntarily given with full knowledge of the charges against you?
How can you say that again? I'm sorry.
Sure. Do you understand that this guilty plea, is it being given freely and voluntarily
yes.
and with full knowledge of the charges against you and all the facts and circumstances related
Yes,
to
sir.
those charges?
Yes, sir.
Okay. Now, Ms. Vaughn, do you understand that if the court imposes a sentence that you ultimately choose to accept, you would have only a limited right to appeal your guilty plea conviction?
Yes, sir.
And do you understand that you would have only 30 days from today to file a direct appeal of your conviction?
Yes, sir.
Do you understand that you would have until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes, sir.
And do you understand that if you wish to challenge the voluntariness or any constitutional aspect of your guilty plea, you must do so by filing what's called a habeas corpus petition?
Yes, sir.
And do you understand that because these are felony offenses, you would have only 4 years from today to file a habeas corpus petition?
Yes, sir.
And do you understand that unless she chooses to withdraw, your attorney will represent you until the end of the current term of court or 30 days from today's date, whichever is later?
Yes, sir.
And do you understand that any of the filings that we've just discussed must be filed by your attorney unless you choose to represent yourself?
Yes, sir.
Okay, thank you very much, Ms. Vaughn.
Problem.
Your Honor, regarding the factual basis for these pleas, beginning with the case number ending in 989, on December 13th of 2020, officers with the Atlanta Police Department were called to respond to a report of an accident with multiple injuries on I-285 southbound at Arthur Langford Parkway. There were 4 different people involved in the collision of 2 vehicles. All had been transported from the scene by ambulance at the time that investigators with the accident investigations unit arrived on the scene. That unit completed a full investigation into the circumstances surrounding the vehicle crash, and the results of that investigation were the following: that on the day in question, December 13th, a 2017 Chevrolet Cruze that was being operated by Ms. Vaughn struck the face of a guardrail on the west side of I-285, about 50 feet north of the exit ramp to Campbellton Road. The Chevrolet came off of the guardrail, crossed all 4 lanes of travel before striking the median wall, and then was rear-ended by a Nissan Altima that was being driven by a Mr. Cabre, Kebre, Whitelock, Whitelock. The investigators obtained a warrant to conduct a search of the airbag control module. And once obtained from the Chevy Cruze, they learned that the Chevy Cruze that was being driven by Ms. Vaughn was traveling at about 75 miles per hour when it struck the guardrail north of the exit ramp. It also indicated that there was no braking by the driver during the collision and that there was no steering correction once the vehicle left the roadway. Ms. Vaughn's 2 children, 3-year-old Sameze, Sameze Vaughn, and his 8-year-old brother Saw were unrestrained inside of the vehicle. 3-year-old Sameze was in the back passenger seat and Saw was in the front passenger seat. Neither of them were wearing seat belts or were in any type of car seat at the time of the collision. The 8-year-old Saul suffered a broken collarbone and some other injuries, but ultimately recovered. But 3-year-old Samiz was transported to Children's Healthcare of Atlanta, Eggleston Children's Hospital, where he was later pronounced deceased. The doctors confirmed that the cause of his death was blunt force trauma as a result of the vehicle collision. The investigators with the Accident Investigations Unit ultimately determined that weather, roadway conditions, time of day did not play any kind of role in the accident. Grady Hospital, while treating Ms. Vaughn, did obtain a blood sample, and a later toxicology screening showed the presence of benzodiazepines and fentanyl in her system. There would have been no medical reason for the presence of the benzodiazepines or the fentanyl, neither of which had been prescribed to her or administered to her during the course of her treatment at Grady Hospital. The 8-year-old Saul, who was also involved in the collision, also reported to his guardian that, quote, "Mama took some pills and kept falling asleep." And so ultimately the investigators ruled that the cause of the collision was a result of Ms. Vaughn ingesting the benzodiazepines and fentanyl and most likely falling unconscious at the wheel of the vehicle. Turning then to case number ending in 011.
Before you get there.
Yes, Judge.
How did Mr. Whitelock do? Is he okay? Did he get injured?
So, Judge, I did try to look to see about the extent of any injuries to Mr. Whitelock, only that he was injured, but unfortunately, I don't know any of the details of his injuries. It seems like the investigators obtained warrants for the medical records related directly to Ms. Vaughn and her children. Ms. Rios might be able to correct me on that. But he was transported from the scene by ambulance, as all 4 of the parties that were involved in this crash were. In the case number ending in 011, Ms. Vaughn essentially rented a vehicle from Hertz Rental Car Company and kept it longer than the rental period that was provided for under her contract. And Hertz reported that vehicle stolen. And so that is the basis for the other indictment. Ms. Vaughn does have 3 arrest cycles, but no prior felony convictions. And 2 of those arrest cycles involve the charges in these instant indictments. And looking into her history, I was unable to find any instances of similar conduct with respect to the operation of the motor vehicle while under the influence of drugs.
Okay. Saul, how do you spell Saul?
Saul, I'm sorry, Judge,
Saul.
S-A-U-L.
Got it, like King Saul, got it. And Saul is in whose custody now, if you know?
He's under the care of a guardian. One moment, Judge.
I don't need the name, but Saul, it's not that Saul is with DFACS, there's a guardian in the mix.
It's my understanding that he's in the custody of a male guardian who he made the outcry about the sort of nature of the collision to.
Okay, all right, appreciate it. Ms. Rios.
Yes, Your Honor. Ms. Vaughn is 32 years old. I wanted to give some background about what was going on in her mental state when this incident happened. So she lost her mother, who she was living with, 2 weeks before this incident. And I believe a month before that, her dad also passed. So she lost pretty much all her family. She doesn't have any relationship with, I think, her only sibling, her brother. And she was living with her mom at the time, and her mom was paying bills to the house. So that when her mom passed, it left her homeless. So
And was her mother's passing a sudden situation?
I-
Or it was building up because of a long-term illness?
my understanding was sudden, right?
She had diabetes. And she just passed away.
So it seemed like she had an underlying health issue, but with diabetes, I guess.
It can be sudden. Okay.
So she was diagnosed with major depression disorder. And around the incident, of course, she had no intention of hurting her children. She thought she was okay to drive. And honestly, she just was going through a lot mentally at the time. Her son, she had told me that her son currently is in DFACS custody, and she has been trying to see him, been trying to get him out. She wants to, she feels awful that he has gone through losing a sibling and now in DFACS custody and how traumatic that is for him. So she wants to be able to have a relationship with him, do whatever DFACS is requiring of her so she can eventually have custody of him again or be in his life. As you heard from the state, she doesn't have any instance like this. She doesn't even have an extensive criminal history, no felony convictions. So this was an isolated incident due to the grief that she was going through of losing two parents so suddenly close in time, and having the stress of having to still take care of her children and deal with this grief. And she seems to not have been able to get the mental health support that she needed at that time. And that's why this incident occurred. She's currently 7 months pregnant. She did have a relationship with the father. I have spoken with him and texted back and forth with him. I'm not sure the status of their relationship right now because he stopped responding to me, but
The father of the child to be or the father of
that she's
Saul?
the child to be.
Okay.
He was supposed to bond her out, but he never bonded her out. And she does have a friend that she can go stay with, who I've spoken to, who.
Is this the same friend? I know when we had discussions about bond, Ms. Vaughn said, I've got this friend and that's where I can stay. Same person?
Yeah, same person. I've spoken to her a couple of times and she can stay there once she, if she's released. And we're asking for 10 years probation, considering the circumstances of what led the surrounding circumstances of the incident. I think the fact that she's lost a child is punishment enough. Honestly, every time I come to see her, she's in tears. And so I'm just hoping that she'll be able to be out and not give birth to her child in prison and be able to hopefully get her other child back with some support.
Ms. Vaughn, have you been able to get any treatment for grief and depression while you've been in custody?
No, sir.
Have you asked?
I don't know who to ask.
Is there anything you want to add to what Ms. Rios shared?
She basically said anything. It's a mistake, sir. Honest mistake. Like, I didn't mean for it to happen. Like, I just been going through a lot at the time. And I was just going to the quick trip just to park so I could go to sleep. And I don't want to have my son here. I just want to be with my son.
1 second. Got it right there. I had a case similar to this recently. I'm just trying to get information on that.
Were you looking for me, Your Honor?
I was not. Thank you.
Oh, okay, I'm sorry. I thought I heard probation.
Oh, thanks.
Yes, Your Honor.
But we'll need you in a little bit, so don't go anywhere.
Right here.
Let me ask this while we're doing that research. Ms. Rios, no one talked about first offender. Is that not something you can get for homicide by vehicle? It may not be something for which Ms. Vaughn is, it sounds like she is otherwise eligible.
Yeah.
I just don't know if this offense of conviction is eligible for that, or it may be that you agreed you wouldn't seek that. I just don't want to leave it on the table if that was something we should have been
So
discussing.
that is something that we should discuss. I would want to know, can both cases be wrapped up in?
Oh, right, it's two cases. I forgot about that. They can be consolidated for purposes of sentencing, and we can do that. I'm not particularly focused on the Hertz case.
Yes.
Um,
And I can quickly go over.
I'll handle that part if we're gonna do it, but I need to know if you can get first offender for homicide by vehicle in the first degree.
I don't know about that question, Your Honor, but unless both cases could be tried together, they can't be consolidated for trial for purposes of the code.
They would not be tried together. I mean, it would only be because the defense asked for some unorthodox joinder. They are unrelated in time, subject matter, et cetera. So then that sort of makes it move. I'm happy to do first offender on one of them.
Yes.
If
Well, I would request that we do first offender on one, because then it's just one conviction.
okay, all right. Well, why don't I have that conversation? Oh, here we go. The info I needed just popped up. Thank you, Ms. Nelson. Okay, great. Mr. Shapiro, was there something you wanted to add, or?
Yes, Judge. Addressing the issue of whether or not Mrs. Vaughn is eligible for first offender treatment, doing a review of OCGA 42860, it appears that while the murder charge would be ineligible for first offender treatment, homicide by vehicle appears to be a first offender eligible offense.
Okay, I'm gonna apply it to the death by conversion anyway, just to have that have as little impact as possible on Ms. Vaughn's life. But let me talk about first offender with you, Ms. Vaughn. First offender is something that you are kind of eligible for. It's tricky because you have two cases right now. But for your Hertz car case, you are eligible for first offender, which is a situation where if I sentence you as a first offender, if you successfully complete your sentence, it goes away. It's not a conviction, and you don't need to report it as a conviction to anyone. Now, you're going to get a conviction flowing from the death of Samis. So in some ways, our discussion is a little academic, but I just want to make sure you understand how first offender works, and that for your Hertz car case, I'm going to apply it. Okay? Any questions about that? No? Okay. Ms. Vaughn, I find there's a factual basis for your plea in both cases. I hear you clearly that you didn't intend, who would intend to have what happened to Samis happen? And I know you will carry that as a burden everywhere you go, every day that you are awake and breathing, you are going to think about what happened. And so I don't look at you and think there's a killer. I do get cases where it's a cold-blooded killer who pulled out a gun and knew exactly what would happen when he pulled the trigger 14 times and shot someone. And that's not you. But we still have someone who, even though it was a difficult time and you had lost your parents, you made a series of decisions, it's not just one, that put your two kids in such grave risk. You as well. We're fortunate that you ended up okay. And it sounds like Mr. Whiteblock was okay. I'm not saying that he doesn't have scars or still doesn't have a limp, but he clearly didn't die, because there'd be a whole other charge that we're dealing with. And no one else got hurt. 285 is a scary place to be going that fast when you're sort of drifting in and out of consciousness. And that degree of recklessness, I think that's a fair word. It's not evil intent or malice or anything like that, but that recklessness, that's something that carries with it some pretty serious consequences. I think you've already experienced the most significant consequence, the loss of your child, as in the child who's deceased. The potential loss of Saul, I don't know that the people who make those decisions will say that it's okay for Saul to be back in your life. I hope so, for your sake and for his, but I don't control that. But I just want to emphasize that I appreciate Ms. Rios's perspective on this, but this is more than just a mistake in my mind. A mistake would be when you're closing the car door, you didn't notice that Saul's hand was sort of in the way and you accidentally closed the car door. One little thing, and that's terrible, and you would never want to do that to someone. And we rushed all to the hospital. But this was a series of things that resulted in a much, much more serious consequence. With that in mind, I find that there's a factual basis for both your pleas, that your pleas were knowing and voluntary. Knowing means you've understood all the things we talked about. Do you agree with that?
Yes, sir.
And voluntary means that no one's forced you to enter these pleas, but you've decided after thinking about it a lot, talking with Ms. Rios, that this is the way you want to move forward. Is that correct?
Yes, sir.
Okay. I'm sentencing you pursuant to the Probation Options Management Act. And that means that while you're on probation, if you have a small problem on probation, you and probation will work to resolve that. But if it is more significant, you get arrested for something, that comes back to me and I will work through the consequences there. Ms. Rios, do you authorize someone in my office to sign the 2 indictments on your behalf?
Yes, sir.
Mr. Shapiro?
Please, Judge.
Ms. Vaughn, is it okay if we electronically put your name on the indictments indicating your pleas?
Yes, sir.
Okay, we'll do that. Ms. Vaughn, in 00SC09016, I will sentence you as a first offender, and I'm sentencing you to 2 years to serve on that case. In 23SC191989, I am sentencing you to 8 years to serve 2 years with the balance on probation. You will get credit for the time that you've served. You will have additional time that you need to serve. All the other counts will be dismissed. So that's count 2 that I have that sentence for you. The 2 sentences will run together. So it's a total of 8 years to serve 2 years. Again, credit for the time that you have served. A special condition of your probation is that when you are out and reunited with friends or your kids, that you submit to a mental health evaluation so that if there's medication that you should be taking that will help you work through the depression and other issues you may have, you'll get some treatment. And if any treatment is recommended, that becomes part of your probation. So if that's go to counseling, take medication, you complying with that treatment is part of your probation. And I will also have as a condition of your probation that you get your GED. You got partway through high school, but I want you to get your GED because you're going to want to be working so that you can provide for your family, and your GED will help with that. So it's first offender, 2 years to serve on the Hertz car case, and it is 8 years to serve 2 years with the balance on probation for your vehicular homicide. Those 2 cases run concurrently. You get credit for time served. That's different from what Ms. Rios asked for. It is also different from what the state asked for. It is consistent with another case that I handled recently with a similar scenario where a mother, instead of fentanyl, it was alcohol, doesn't matter. And she drove and her child was unrestrained and her child died. And it was nothing intentional, but it was a series of really bad choices that had horrendous consequences. I think it's important that those sentences align a fair amount. And that's just so people understand the origin of where I come in between the 2 recommendations. But today is the last day you could withdraw your plea if you don't like the sentence you get. And that's okay. We'll get you back where you were. And it just means that we're gonna have a trial on the case. So we'll need to bring Saul in to testify and the officers in, and they'll find Mr. Whitelock and he'll testify. But you have an absolute right to that trial with Ms. Rios as your lawyer to get you through that if that's what you want to do. I'm going to ask the 2 of you to talk for a little bit so that Ms. Rios can give you her thoughts about whether you should go forward knowing your sentence or instead withdraw your plea, which is fine. There are no negative consequences for you. And instead go to trial where if you're found guilty, it may be a very, very different sentence because all these other charges that are being dismissed won't be dismissed. The jury will hear about all of them. Do you have any questions of me before the 2 of you go talk?
So you said 2 years served 8 years, but served 2 for the murder too,
For the
Correct,
for the homicide.
right?
And then I already did 5 months. So the other 2 years is not with the other, like.
Yeah, they're running at the same time, so you have two clocks that are ticking at the same time. The Hertz case is not gonna change anything for you. I just gave it the same number and it's gonna run at the same time. The one you should be focused on is, the vehicular homicide. And you've heard what I am prepared to do. You come in here and accept responsibility, which you did, and you shared with me how terrible you feel about what happened, which I would expect. And I'm gonna say one last time, I know you're gonna carry that pain and that shame with you on, way past 2 years from now, way past 8 years from now. And frankly, that's part of the punishment that life is giving you for having done what you did. And I'm factoring that in. I don't think the state's recommendation was unreasonable, the 5 years. But I think that fits better if you had been more intentional about things, as in, I'm gonna show you, Samis, I'm gonna make you sit in the back seat instead of the front seat. And that wasn't what you were doing at all. You were in a real tough situation and made a series of very risky decisions that had bad consequences for people you care a lot about. And we're here now, okay?
A question.
Yes, ma'am.
Do I serve this in county jail or prison?
You would go into the Department of Corrections. You would not be here you may be at ACDC, but you would not be in the collection of county jails.
Okay.
All right, Ms. Rios, why don't you speak with Ms. Vaughn and let me know what we're gonna do?
We've discussed, Your Honor, and she would like to move forward, please.
Okay. Ms. Vaughn, I'm gonna see if Officer Evans, who is with probation, needs to give you any reporting instructions. I think it will simply be upon your release, you need to report, but let's hear from Officer Evans.
Yes, Your Honor. I'm sorry.
We're ready for you. Ms. Vaughn is going forward with her plea. In one case, there's no probation, and in the other case, there is probation, but it will be after she completes service of some time in custody. So I just want to make sure if there are things you need to tell her, you get a chance to do that.
Yes, Your Honor, I can provide reporting instructions, although we know that she'll be in custody for quite some time. If I could just have your address, your current address, Ms. Vaughn?
I don't know that she's got one.
Okay.
I can just give the friend's address. I'm not
Okay.
sure, yeah.
So there was a friend with whom she was going to stay when she got out. We never locked that down. So I don't know that that's an address that you should put in the system. I think It would be safer to just let Ms. Vaughn know when she needs to report.
Yes, Your Honor. Ms. Vaughn, you're going to report to 276 Memorial Drive, Southwest Atlanta, 30303. Telephone number 404-463-0410. You're going to report there within 48 hours of your release. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
And if you could just provide a good contact number for possibly like your mother or your sister or even your friend, someone we will always be able to contact.
My friend, I don't even have the number though.
Okay, don't worry about it. Just report to that address and that telephone number once you are released, okay?
Ma'am.
All right, thank you, Officer Evans.
Thank you, Your Honor.
Thank you, Ms. Rios, for your work on behalf of Ms. Vaughn, and Mr. Shapiro for filling in for that lazy bones.
Can you let my friend know what happened?
Mr. Jordan.
Of course, Judge. Happy to do it.
Take that picture.
Your Honor, I think that concludes my business.
You want me to
Please
call
use-
the-
Yes, sir.
Thank you.
You burn them or something? I'll call.
Ms. Rios, we've got two, I think, quicker things left.
Yes, so Eric Musa would not be a plea, so I guess we're going to just do the final.
Get on the record his no thank you to the offer. And then we have Mr. Owens's revocation, which I think will also be pretty brief. Thank you for covering that for Ms. Wood.
No problem. So, yeah.
Mr. Hort, we are running a little behind, as you've noticed, but I think the longest of the remaining things has already happened. And your client is on now, so has been theory listening if you want. Mr. Musa, how are you?
Good, sir. Thank you.
Good. We're gonna get on the record here in your case. It's 24SC002355. You're charged with aggravated assault and some firearms offenses. And today is your final plea date, which means this is the last day you could enter a plea and withdraw that plea if the sentence I gave you was more than what your lawyer asked for. So I'm gonna make numbers up. The state recommends 2 years to serve. Your lawyer asked for 6 months to serve. If I were to give you 1 year to serve, that's more than 6 months. And you could say, nope, I was willing to take 6 months. I'm gonna go to trial. After today, you can still enter a plea. You can always enter a plea. You can enter a plea in the middle of trial. The only thing that's changing is you don't get to withdraw if my sentence is different from what your lawyer asked for. Does that make sense?
Yes, sir.
All right, Ms. Nix. Well, before I get to Ms. Nix, Ms. Rios, any discovery issues in this case, or you feel like you've got everything?
We're still waiting on a video. I know Ms. Nick says she's tried to get it, but it has not obtained it yet.
Is that video something that would affect your counsel to Mr. Musa? Or
Yes.
it's a, look, it'd be nice to have, but it's not a
The
huge.
video of the actual altercation incident.
Okay, is that what you think the video is of, Ms. Nix? Because sometimes they hear, hey, this is gonna be a super important video, and it shows two fuzzy figures, 200 yards away.
So Judge, this incident was the defendant waving a gun in a convenience store, but not pointing it at anyone, and then going out into the parking lot and where he did point it at the store clerk. There's no video of the parking lot. I understand that there was video of inside of the convenience store. that I've been attempting to get several times from law enforcement. If I don't get it by the end of this week, so tomorrow, I'm gonna march down there and demand it.
Law enforcement, APD, or are we stuck in a jurisdiction where crying it out gets complicated?
I think it's Fulton County PD,
Okay,
if memory serves.
all right.
Yes, Fulton County PD.
But they
So
have it. It's not that you are going to the Quickie Mart saying, could I please have footage? Your understanding is that the police have that footage.
the victim told me that he no longer has it. It was not saved individually and has been recorded over. He does tell me that he gave a copy to the police.
Okay.
And the police isn't saying I don't have it. They're just saying they just haven't responded.
Okay. Yeah.
So
It may exist, and if it does, it's with law enforcement, which means it really is yours to get, and not that Ms. Rios could go to the convenience store and get it herself.
correct.
Okay.
And it doesn't really show the incident because the conduct that the defendant is charged with is what happened outside. But it does support the statements of the witnesses.
Okay. Why don't we keep, I think Mr. Musa is going to the November trial calendar.
Yes.
Why don't we just keep his final plea rights open since you haven't had a chance to see it? It sounds like if the video corroborates what witnesses have been saying, you might be letting Mr. Musa know trial will be even more complicated.
Yes, Your Honor.
And if it shows something completely different, that someone else was pointing a gun at him and he took it in an effort to protect himself, change things as well. So Mr. Musa, all that stuff I told you about your final plea rights, you still have them, but I'm gonna carry them over until the day of the trial calendar.
Okay.
So I'll see you again soon. It's not many weeks from now when we're gonna call the trial calendar. It's not actually the day the jury comes in, but it will be another chance you'll be brought over. And by then, the state's either gonna say, we can't get this video, or Ms. Rios will have had a chance to see it and she can tell you it's a terrible video for you or it's a good video for you. And then you'll have one more chance to see if you want to work the case out with a plea rather than going to trial. Okay? So sorry to spin you around like that. I should have asked about the video first. So I will see you in a few weeks at the trial calendar. Now, if you all sort this out in advance and it's going to be a plea, we can take it much sooner and more efficiently if we don't do it on that trial calendar call day, because that'll be pretty hectic. All right, any questions, Mr. Musa?
No, sir, not right now, not right.
Okay, all right.
I understand.
Good, I'll see you soon.
Thank you. See you at the jail.
Are we ready for Owens? Hello, Mr. Owens.
How you doing, sir?
I'm all right. I'm looking for your paperwork. 1 second. All right, let's go on the record in 22 SC 183872. It is a probation revocation hearing in July of this year, Mr. Owens. I signed a warrant because probation reported to me that you had stopped reporting. They went to your address and they come find you a couple times, and you were supposed to do community service and you had only done a little bit. So these are what we call technical violations, but they're still you not complying with the conditions of your probation. To me, the bigger one is you made it hard for probation to find you, and your job should be the opposite. Here I am. What do you need? I'm here to answer your questions. So we need to have that not happen again. You have 3 months and 30 days, you've got 4 months remaining on your probation in this case. Officer Evans, was there something you wanted to add?
No, Your Honor.
Okay, all right. Ms. Rios, what is Mr. Owens doing? Is he admitting to these two that he's not done with his community service and he was hard to find, or what?
I believe he is stipulating, and I have an email that Ms. Wood sent me for probation. They just want him to be continued and provide updated contact information. I'm not sure, did you?
No, I gave him my address, but he couldn't find my apartment.
Oh, that's what Ms. Wood said. They needed an updated apartment number.
Yeah, he couldn't find
on
apartment number.
Yeah.
Right, let's see. Had you moved around?
I gave him my address when I moved. I moved May the 1st, the end of April, beginning of May. He had me to take a picture standing in front of my door. So I sent him everything he asked for. He just couldn't find it when he came out there.
Are you on Landrum,
Yes, sir.
apartment 19F?
Yes.
Okay, the 19F is probably what's throwing them off, because the address that's on the warrant is 3041 Landrum Drive, but there's no apartment. What is the right apartment?
19F.
19F, okay. It also says Landruff, like dandruff in the computer, but I think probation knows it's Landrum.
Landrum.
But they need to add the 19F. Okay, who lives there?
Me, my wife, my kids.
How many kids?
6.
Does your wife work?
Yes.
What does she do?
Well, she was at, she door dashing at the moment. She was at a place called some kind of warehouse, Stecco or something like that.
Okay.
And I work for Mannheim.
How old is your oldest of 6?
20.
How old is your youngest?
She just turned 9.
The 20-year-old still lives with you?
Yes, he on the way to the military.
Yeah. They all, is 19F like a 12-bedroom apartment?
I wish, no, it's just a 3.
So how do 8 people fit in the 3-bedroom apartment?
3 girls in 1 room and 3 boys in 1 room.
And mom and dad in the 3rd room? Okay. How long have you been at Mannheim?
I started the Monday before I got arrested. I got arrested on the 10th. I started that Monday.
What about community service?
I got 6 hours left.
I understand, but you've been under sentence for a while. When are you gonna knock out those remaining hours?
He said they're gonna take me number 2 days to do it when he came down Friday to see me. So I'll get that on out the way, and I gotta finish my family violence class.
When you say he, is this Officer Watson?
Yes.
The person you've been working with?
Mm-hmm.
Okay.
Your Honor.
Yes, ma'am.
It appears that a palm waiver may have been served to this defendant. As he stated, there was communication between him and his officer, Officer Rollins. I'm just now seeing this. I can
Well, he
send it
told me-
over to you.
He told me he has Officer Watson.
Yeah, I think that's the supervisor or something.
Right.
Rollins.
Okay. All right, yeah, if you want to send me what you've got, I don't want to
Absolutely.
double ding Mr. Owens, but he's been on probation before. He knows what he needs to be doing.
Yes, Your Honor. I'm sending it to you right now.
Thank you.
I just sent it over, so it should be there in like 2 seconds. I was entered in the 22nd. It was done on the 18th.
Craig Owens. Is your wife Ms. Embry? Or is that someone else?
No, that's my wife.
Have you done the family violence intervention program?
No, I haven't. I had the money. That's what we spoke about Friday. He said he was gonna he said he has some kind of program going on.
Yeah, something different, because you won't finish family violence intervention program with the time you've got left. Oh, it's got it. I don't know what he checked. He said complete family violence intervention program by
The second.
February 2nd, 2025. Oh, I guess you'll still be up before. I guess you'd be squeezing it in, my friend. All right. There it is. There's Rawlings, and you signed it. Okay. So I don't think we have anything we need to do here. Given that, would you send me Officer Evans a warrant dismissal? What do we need to do?
Yes, Sharon, I'm gonna reach out to them and get that warrant dismissal over to you.
Okay.
That's what needed to be done.
All right, and that'll get Mr. Owens out.
Yes, Your Honor.
It's pretty low impact. You don't have a lot of probation left. Try to make it work.
I'm gonna get it together for you, Your Honor.
Don't do it for me, man. Do it for those 6 kids.
Oh, definitely. I got more than that. That's just the 6 that's with me.
Okay. Don't get in trouble again.
All right.
Thank you, Ms. Rios.
May I be excused?
Yes, thank you for your help today. Some complicated cases.
So sorry.
And do I see you tomorrow? We got a final plea. Okay.
It's mostly me tomorrow again.
All right, great. All right, so Ms. Jackson and Officer Evans, thank you for your time. We are done with anything that's going to resolve in a plea today. So I appreciate your service, and I will see you guys tomorrow. I think it's late morning or just afternoon.
Yes, Your Honor.
Have a great one.
Bye-bye.
Bye now.
Okay. Mr. Horton, you should come on up as Ms. Rios transitions out. Mr. Horton, if you could move the screen on your desk a little bit, so you are more centrally in the screen, so your client can see you.
Your Honor, in case they are in a waiting room, I just wanted to mention, I believe, the victim's family and the other victim might
You
have.
don't have a waiting room, so.
Okay.
They are more than welcome to be involved, but it's a straight dial on and,
I just wanted to make sure.
okay. Do they have the link? Because if they don't have the link, you can share it with them or I'll get it to you to share.
It is my understanding that Ms. Rolak had sent them the Zoom link that I
Okay.
forwarded
Yeah,
her.
there's not a waiting room isn't set up, so they're in if they're one of these folks.
I can't see who's there, so.
Oh, okay. Well, I don't need to say the names, but there are a number of people on who I don't know, so I'm assuming some of them may be affiliated with the deceased.
They should have the last names of Grigley or Blaylock.
Nope, we have an Allen, a Maddox, a Wise, someone with a last name that starts with the letter A cell phone with no identification, and someone known as Dine Out Deliveries.
Okay.
So 2 of those could be with those last names.
Okay.
But why don't you just coordinate with Ms. Rolak, and if we need to push the link out again, I'm fine with it.
It's the link that was sent to Mr. Hort, so
Okay.
it's
Same one.
the same one.
Yeah, all right. So let's get on the record in 00SC09016, State versus Leslie Singleton. This is another installment in the hearing we're having in connection with Mr. Singleton's case here, which was a murder trial that resulted in his conviction, and a motion for a new trial that was not timely pursued. Mr. Singleton, can you hear us?
Yes, sir.
Great. All right, thank you. It's good that you're on mute. You pop back on mute. Just let me know if you can't hear things, or if you've got a question, wave your hands, do something, or if you're the one who controls it, you can unmute it and just say, wait, I don't understand what someone just said. It's important that you follow what's going on, but you are appearing virtually at your request made through your lawyer.
Yes, sir.
Great. I asked the lawyers to focus the start of today on an assessment of the due process impact of the delay that we have discovered in this case. It is, I guess, a slightly modified Barker v. Wingo analysis about the length of the delay, the reasons for it, Mr. Singleton's assertion of his right, and then most importantly, the prejudice, and meaning the impact that it's had on Mr. Singleton, which can mean most directly, it's stressful to be in custody, but that really wasn't my focus. I don't mean to ignore that element, but my focus is much more, how is Mr. Hort's ability to meaningfully argue the amended motion for new trial, and if denied, an appeal to the Supreme Court, how has that been prejudiced, negatively impacted by the excessive amount of time that has passed? So I want to open it up to that. Often the way these work, when it is a constitutional speedy filed by a defendant before he's had a trial, it's actually the state that takes the lead with the hearing as they seek to demonstrate that the amount of delay is not in dispute here. It would be more the reasons for it, and then the remaining 2 factors. But I'm open to, obviously I will hear from both sides, but I'm open to moving forward in whatever way you all, if you've discussed it, you want to. I know Mr. Hort has already filed a response to the court's prejudice inquiry, as he framed it. That right here, I read it. But I'm ready to tackle this in whatever order you want. Do you have a preference, Mr. Armstrong, or did you and Mr. Hort talk about this?
We've not discussed it since the court told us what we were going to be doing here today.
Okay. And so we're clear. What I said is this is what I want to start with. If we get through it in 10 minutes, then the ball is back squarely with Mr. Hort. He has the witness list. He's gonna go through, we'd be back to, let's get back to the substance of the motion for a new trial. Not that this is non-substantive, but the reason why, I don't mean to be mysterious about it, the reason why I brought it up is I have wrestled with this in a parallel situation I've encountered, is if the prejudice is sufficient, I intend to say we can't go further forward, and there can't be a meaningful motion for a new trial. But that order would be of a type that would be directly appealable, and we ought to get that going with the state so that we continue to make progress. But it may be that it's not appropriate for me to short circuit things because there isn't an adequate showing of prejudice, or it turns out that the reason for the delay falls only in Mr. Singleton's lap. I don't think that's what we're going to find, but I'll be open to hearing on all that. So why don't I start with you, Mr. Armstrong, and why don't you share with me your thoughts about the Barker v. Wingo analysis and whether it's even appropriate. I didn't pull it out of thin air in doing some thinking. I got into Westlaw, which is always dangerous for one side or the other. It turns out it was dangerous for the state, and ran into a series of cases where the Supreme Court wrestled with this because a judge said either no, it's not a due process violation, even though so many years have passed, or yes, and that was appealed and the Supreme Court ruled on it. And that's what got me connected with the Barker v. Wingo framework in a post-conviction setting, which is how it's normally applied.
Yes, Your Honor. You probably saw Chapman versus Mansell, which I'll spell because neither of those words are normal. Chatman versus Mansell, Mancill. That's a Georgia Supreme Court case where it adopted the.
Give me the site.
Yes, it is 280 Georgia, 253. That is the case where they determined the rubric for speedy appeals. I believe that it is something that the defense has the burden of showing, primarily because in prejudice, that's something that has to be shown by the defense. And so unlike a pretrial circumstance, it's that. I don't have a quick and easy citation to give you that says just that for all four of the factors, but prejudice has to be shown by the defense.
Very much so. And I'm sure that I saw citations to Chapman. I was more current than that. I was looking at Dela Cruz and a couple others, but they must have cited Chapman because they invoked Barker v. Wingo, so that Chapman was in there.
Correct.
And more importantly, what I took from that is the reason why it's kind of Barker plus is that prejudice piece where it's not enough to say, gosh, things could have been bad. The defendant, through counsel, must show that, no, here's the prejudice, putting a bow on it, not, gosh, it could be complicated if we did go forward to trial. And so I'm fine starting with Mr. Hort. I also didn't find something saying, here's how you divide it up. You're both going to talk about all four factors. I don't think anyone needs to spend a whole lot of time on the length of delay.
No.
It's a big, ugly number. And there isn't a way I'm going to find that that's not presumptively prejudicial, but that's just one of four factors that we weigh, that weighs against the state. And then we just need to suss through the reasons for the delay, and then how to characterize some of what Mr. Singleton has been doing since he started working with Mr. Greenberg in terms of invoking his right, saying, wait, I've got this right to be heard, and assess it against who he is and where he is. He went into prison as a 16, 17-year-old and has been there the rest of his adult life. And so does he know to send a letter that says, I'm invoking my Barker v. Wingo rights because Carl Greenberg's not moving my case forward? I don't think that's the requirement, that there's something that explicit, but he wasn't sending in letters to the clerk. I don't know what he was sending to Carl Greenberg saying, what about my motion for a new trial? So why don't we turn to you, Mr.
Before we do, can I mention one thing to correct something the court just said?
Yeah.
Before I forget. Your Honor referred to presumed prejudice, and that does not exist in this.
Okay.
The presumption of prejudice comes up when you deal with the threshold issue, which determines whether you even get to the four factors.
Got it.
That's often colluded because one of the factors is the length of the delay, but that's not something that's at issue here. The four factors are, but not that for that initial threshold inquiry where the presumption of prejudice comes up.
Okay, you're exactly right, and I was a little sloppy in the terms I used. Let me put it this way, don't waste your time talking about length of delay.
Absolutely.
Let's focus on the other three factors. In particular, I want the state's assessment of factor 2, reasons for delay, and Mr. Hort's assessment on number 3, defendant's assertion of his right, but most of all, number 4. The ball's with you.
Thank you, Your Honor. May we approach the bench?
Okay. It's not my usual courtroom, so I don't know. Why don't we go over here? That's fine. And you want to step outside or just be right here?
Outside would be.
Okay. Let me get you in.
It's a polar.
It's either. All right. Cool. Come on. That's not looking for me. No, that's what. I'll make free drinks on car.
Is in here. Okay. Yeah, he's in here for us. Again, well. So, yeah, okay, that's fine. So, check on. Say it needs to sell. I'll back on next year. Yeah. Okay. I'm because the index I board, I would take that. Okay. But not gonna go all these in there, but it's nice. Oh, I should use. Yeah.
You press that green button to go over there. Yep. All right, Mr. Hort, thank you for sharing that. And I am turning to you. You can address all four factors if you want, but again, Mr. Armstrong again. Yes, sir.
I think you wanted it so Mr. Singleton could see all the participants. He can't see the podium right now.
I can switch it to podium. Do you prefer to stand or sit? I am
Stand.
neutral, but if you prefer to stand, then I will do this and get you on the screen. There we go. All right. Everyone we need to see, we can see.
And Your Honor, I guess I ask, do we need to put anything on the record so far as our off-record conference?
I'm happy so that the record and Mr. Singleton know that Mr. Hort shared with me, with Mr. Armstrong present, Mr. Hort's vision for non-trial, non-appeal resolutions to the case that he wants to be able to share here in court on the record. He just wanted to make sure that talking about that wouldn't run afoul of something. And I told him I'm open to having him get all that on the record as part of his presentation.
Thank you, Your Honor.
You bet.
Your Honor, as the court has acknowledged, I did file a response to the court's request with regards to prejudice. I would incorporate that in my comments, and I would instead now try to highlight in conjunction with the court's comments today.
Before we go, I just want to clear up one thing. So we have one of the people on is associated with the Grigleys, just has married and so has a different last name. So they're
Thank you,
plugged
Judge.
in. Great. Thank you, Ms. Maddox. All right.
Thank you. Barker versus Wingle is the United States Supreme Court. And I realize and appreciate that Georgia has tweaked what was said in Barker versus Wingle. But I would ask this court to follow the United States Supreme Court. This case offers an opportunity for the court to do that. And I think even though you must do as the courts have indicated, I think as part of your consideration, you can consider that this was a 16-year-old juvenile who is now turned 40. During that time frame, this juvenile has been in the prison system. And as I pointed out in my response, the Georgia prison system is not highly valued, certainly by the United States. Also, as this court knows, my client would not even be here personally in court because he's afraid of Fulton County. And I realize that's not the fault of Mr. Armstrong, the state, or this court, but it does go as to one of the Wingle factors so far as the stress involved in being incarcerated. Wingle talked about a speedy trial, but the factors also then apply as to the request for a new trial. The court has already determined that the delay was unreasonable. Why was the delay? And I think there are two reasons there. One, yes, the state, because the state is an officer of the court and its responsibility is to pursue justice. Two, I think there also was a responsibility upon the trial court, and I guess I add a three, appellate counsel. If the trial court, when the state filed that motion for appointment of substitute counsel in 2005, would have looked at this case, they would have realized that appellate counsel Greenberg was doing nothing. They would have appointed substitute counsel. Substitute counsel then would have talked to Mr. Singleton. And in talking to Leslie, he would have found out, or she would have found out, that Waters refused to testify at the Clayton County case. And then why? And then in conjunction right there, there would be this tip, this finding that Waters had changed his testimony, that he now was saying, I lied at the trial. And that's one of the reasons I'm going to cite to you today. Judge Downs then would have overturned that conviction. And that conviction would have been overturned within a year or 2 years of the conviction. And then a new trial would have been appropriate. It would be timely. Witnesses would still be alive. Memories would be much more refreshed. And the answer would have been there. So I do lay some responsibility on Judge Downs, even though my colleagues tell me she is so highly esteemed amongst the defense attorneys. But I do think she should have looked at it. But more than anything else, I lay the blame on Carl Greenberg. If Carl Greenberg would have done his job, he would have talked to Leslie, and he would have found out about Waters. He then would have found out that Waters had changed his testimony. And again, Judge Downs, being Judge Downs, would have granted a new trial within a year or two of the old trial.
You have referred now several times that Mr. Waters changed his testimony. I guess he is somehow connected to the Clayton County case.
Yes.
Because he was going to be a witness there, but refused to testify.
Yes.
Okay. You contend that Mr. Waters now would say, if he were here in court, what I testified to in Mr. Singleton's trial isn't true. And we don't need to get into the parts of it that weren't true, other than one question I have. Is Mr. Waters going to say Mr. Singleton wasn't there and had nothing to do with it? Or it's going to be what I might call shades of meaning difference. He was standing on the left side of the car, not the right side of the car. Because I don't believe anyone contended in Mr. Singleton's trial that Mr. Singleton was the gunman. He got in the car and I think drove it away.
As this court knows, parties to a crime is everything in Georgia. And in answer to your question, if I remember the three different variables, 3 or 4, it's either 2 out of 3 or 3 out of 4. He was there. But, and this is part of the blame that I have as to Gashard and then Greenberg for not pursuing it. If Gashard would have cross-examined the state witnesses or presented his own expert, the evidence at trial, and we'll show this through our witnesses or through Investigator League, is that Leslie was exiting the vehicle prior to the deputy's shooting.
Exiting the deceased's vehicle?
Yes.
Okay, he had gotten in it.
He was in it.
Okay.
And then he was exiting. In fact, he was already on the passenger seat when he was shot by the deputy. And again, remember, this is a deputy that nobody knew was a deputy. And I realize that's not a defense per se, but I do want the court to understand that.
He got killed, and that's the tragedy here.
So he was exiting the vehicle, in fact, had moved over to the passenger side when he was shot by the deputy.
And this would come out, Mr. Waters would say, let me give you the real version.
Nope, this would come out through if Gashard would have cross-examined the state's expert witnesses, their forensic witnesses, their ballistic witnesses, the DNA witness, or presented his own expert. I am no forensic or DNA expert, but the evidence is pretty clear, and you'll hear that from my investigator, that that is what happened. It's not something we're making up. It's not something that's controverted. That is what's shown by the DNA. It's shown by the ballistics. And then he had left the vehicle, and that also is corroborated by the ballistics when Waters shot the deputy.
Okay.
So, abandonment.
That could be a defense.
Yes.
That Mr. Singleton was on his way of disentangling himself from this carjacking that turned into a murder.
Yes, not only on his way, but he was doing that. He was abandoning it.
As opposed to getting out of the way of the gunshots?
He didn't know about gunshots then. Nobody was shooting. He was just getting out of the vehicle.
I thought you just said that he was inside the car when the deputy started shooting.
He went from driver's side to passenger side, and then he was shot by the deputy.
Right, so he's still in the car when he gets hit.
Sure, I mean, it's not that easy to exit a vehicle from driver to passenger to out the door.
No, I'm not saying one way or the other, but then I'm just understanding the theory here. And so a theory would be he is abandoning the criminal scheme. And look, he got out of the car. Another theory would be I just got shot and the bullets are coming from that direction, me pointing to my left. So I'm going to go that direction, me pointing to my right, so I don't get shot.
And I'm sure that's what the state would argue. But you also need to remember that the jury did come back with significant not guilty verdicts in this case. So it wasn't as if his version of what happened was completely incredible. All I'm saying is Gashard.
My question was, and maybe I wove too many into it, what is it that Waters says differently now that's substantive? Not that Singleton had on blue pants rather than red pants, because Singleton was there. His blood's in the car, presumably, if he got shot in the car. So what has he changed that is meaningful? If it's the 50 things, you don't need to give me all 50. I just sort of want at a high level, what it is that his recantation means that's substantive, because it's not gonna be Singleton wasn't there. And he can't read Singleton's mind, so he can't say, oh, I know he was trying to abandon our carjacking scheme when he was getting out of the way of the gunshots.
Contrary to his testimony at trial in a sworn affidavit in 2024, Waters admits Leslie did not plan the robbery or supply the gloves, mask. It was not all Leslie's doing. Waters admits it was his plan to rob Bacardi. That was the original plan. They were going to rob this drug dealer. His plan to steal the car, the gloves and mask were his gloves and mask, and that he had guns. He'd bought, traded, and used guns to rob drug dealers.
So at trial, he said it was Singleton's idea to do all this.
Yes.
Okay, that's helpful. So that's step one, that those are some meaningful recantations, if in fact he would say that on the stand. Two, how is it that would have been discovered because of the Clayton case, just because he didn't testify?
He refused to testify.
Yeah.
And I think the judge held him in contempt 4, 5, or 6 times, something to that effect.
Yeah.
So that would trigger, why was he refusing to testify? And if Greenberg would have talked to Leslie, he then would have had that question. And you, me, any competent attorney would then get a hold of Waters' attorney and say, hey, why didn't he want to testify? What's going on here?
And was Waters called to testify on Singleton's behalf in Clayton, the state's behalf?
The state's behalf.
Okay.
And if you want to know my guess is that he realized that his promise of 14 years wasn't going to happen.
Waters' promise.
Right.
What did he end up getting?
He's still in prison.
What did
Life.
Oh, for the Clayton case?
No, for the Fulton County case. He pled guilty.
Being the shooter.
Yeah, being the shooter, got life. To serve 14 was the wink promise.
Okay. But that didn't happen.
Didn't happen.
Okay.
And I'm told my investigator when he talked with him that he also had got involved, I think, with Islam.
Yes.
Islam while in prison or while incarcerated.
Waters did.
Yeah.
Okay.
And I think by that he also had a come to moment.
Okay. All right.
So anyway, if Greenberg would have pursued that again, Judge Downs would have granted that motion for new trial in 2001, 2002. And then all the issues that we have here today would not have happened. Now, there are other issues. If Gashard would have pursued the motion to suppress, i.e. that Leslie gave a statement to the police that was then used at trial in return for their promise to help get his mom out of jail. If Gashard would have pursued that, it would have been suppressed. If Greenberg would have pursued it, then Judge Downs would have found that, again, another error that would justify a new trial.
But what we're talking about right now is the reason for the delay.
The reason for the delay, one, the state as an officer of the court; two, because the court did not follow through; and then three, Greenberg, because he did not do a minimal level of competence.
I mean, other than filing the entry of appearance, is there anything in the record showing that he did anything at all?
He filed the form motion for new trial that everybody files. I'm guessing that's, you can Google it and get it.
I don't know if there was Google back then, but I'm rolling.
Okay. He probably had one from other cases where he could, back in 2001, I don't know if you can cut and paste either. He may have had to actually tape.
Yeah. So
anyway, back to all of that. Why is that prejudicial? I can still raise those issues today. The reason why it's prejudicial is, and I mean no disrespect to the appellate courts or the trial courts, but all you need to do to say as an attorney, trial strategy, and then it's no longer error. That's why I say this case offers you an opportunity. You've got a 16-year-old juvenile. You've got two attorneys, Gashard and Greenberg, that came nowhere near close to even the minimum standard this court or any court should or would expect of an attorney, whether it's trial or appellate. Greenberg has mental health issues, and by that we've received a letter, statement, whatever you call it, from his doctor that he can't testify. So we can't ask him about these things. What would he say? I have a hard time believing that it would be acceptable to this court if he were to say trial strategy. Likewise with Gashard, I have a hard time believing if he had not passed away, if we were able to call him as a witness. One, I'm not so even sure that he would continue to say trial strategy. And two, I don't think the court would accept it based on what he did. There was a number of objections he did not make. And I recognize nobody, whether it's this court or any other court I've been in front of, likes my error with regards to not objecting to leading questions.
I like that you've been called out by the appellate courts now. I'm gonna use that in my motion for new trial I'm working on.
Good.
Yeah, you're
I'm always-
up there now.
There's one former judge to another. I'm always glad to help my colleagues. But that nowhere near comes close to his failure to object to the detective vouching for the credibility of Waters. And again, Judge Downs would have granted a new trial on that. Greenberg, if he would have done that, done his job, he would have raised that as an issue. And now because Gashard has passed away, because Greenberg has mental health issues, I can't call them as witnesses. I can't even talk to them to find out, am I missing something? Was there a motion to suppress and it just wasn't recorded or transcribed? That's the prejudice that I'm focusing on for the court.
Okay, we'll get there, because you have some allegations, that may be too strong a term, I don't know where they're coming from, that certain people are dead, I don't know who they are, so we'll get there. It was reasons for delay, and you've identified 3. State didn't act as an officer of the court, and certainly the district attorney's office had an obligation to Judge Downs to say, where are we going with this motion for new trial? And in fact, they did file
2005.
Yeah, 2005. Now, that didn't get us very far, but they did file something. So it's a.
And I give them credit for that. If they were not an officer of the court, if their obligation was not to pursue justice, then that almost would excuse nothing happening during the next 17 years. But that same excuse doesn't apply for the court. And as much as I like and appreciate Judge Downs should have looked at this. And I'm sorry, no respect for Carl Greenberg. You'll hear testimony.
Okay. You're gonna have plenty of time to sink your teeth into him. But that was the 3rd factor. How about your client's invocation of his right? How should I weigh that factor? What in the record can you point me to that suggests until you got involved, he was doing anything? And the answer is he has to have done something because you got involved, and you didn't get involved because he called you. I called you.
Yep. And you called me because of what he did. Now, in talking with my client, he's told me that he did send the letters. But as the court knows, despite the efforts of the court and defense, we don't have the ability to view or even look at the court file. So those letters could be in that court file. Yes, in a perfect world, everything gets put on the internet. But I don't know how much that happened even in 2001. Back then, they may have just put the minimum on. But he's saying that there were letters that he wrote, communications that he made. And I don't know if the state was given a copy of that, if they have copies of that. I know, as one would expect, when you're in prison, you don't always have access to a copier to keep copies for yourself. But he says he did send those communications. And I guess that's also part of my argument to this court, asking this court to maybe pave the way for new ground. Should a defendant be the one responsible for exerting his rights, especially when you're talking about a 16-year-old?
So he's not 16 forever. You have him frozen in time as a 16-year-old, but by 2005, he is 21 or whatever age he'd be. So
20 maybe?
He's not 16.
Okay.
And by 2010, he is even older, et cetera. So
Yep.
he's not forever a 16-year-old.
Agreed. But a
And he
significant
is
portion,
surrounded by a lot of good jailhouse lawyers who are saying, let me tell you what you need to do. I don't know that I should view it only as how he was at the time of his trial.
no, and I'm sorry. 16, 17, 18, I'm trying to think how old my kids were before I felt confident they would do something. High school, college, I remember in college and I had to send my mom a postcard because we couldn't use the phone. So again, we need to go back to 2005, 2010. What was it like then? What could reasonably be expected? And again, his telling me that he did send those communications.
So here's an example. I know you haven't been able to see the paper file, me neither. But in Odyssey, are you able to get into Odyssey? How does that work?
Yes and no. This court has been very good about helping me out with things in his file. And there's also been a member of the Fulton County Public Defender's Office who's been very good helping me to get copies of other files.
Okay, I'm focused on this file. May 1, 2007, entered into the clerk's docket a letter from Mr. Singleton. My reason for requesting my grand jury hearing minutes and transcripts is to prepare a possible ground for my appeal. In your mind, does that qualify as Mr. Singleton as far back as 2007? And there may be one before that. I just bumped into this one in the docket saying, I'm out here and I need help. He doesn't necessarily know to say Parker v. Wingo. In fact, at that time, that may not have been the standard that would apply to post-conviction speedy appeal demands. But here he is in 2007, handwritten letter saying, I need this stuff, clearly because no one else is moving his appeal along.
2 points. One, did they respond? Did they send him that information? I'm going to guess no.
They always respond, but let's see what was responded. Oh, interesting. They sent a letter that doesn't make a lot of sense because it says you sent the letter to the clerk of the Fulton County Commission, and he doesn't handle that kind of stuff. But the letter is addressed to Juanita Hicks, Superior Court clerk, who is in fact the Superior Court clerk. So a double fumble by the county. He did get a letter back, not with the materials he requested. And it sounds like it didn't even get routed to the clerk. But the clerk wouldn't do that. The clerk's not empowered to send records like that. What the clerk does is then send it to a judge who can say, state, what do you think about this? Or sua sponte, dear Mr. Singleton, you have a lawyer, Mr. Greenberg. We'll get him the transcript. We don't also send you a transcript. That's what Judge McBurney would send in May of 2007 when that letter arrived. Didn't happen.
And in conjunction with that, it's my understanding in talking with either Leslie or family that they also tried during this time frame to hire their own attorney. And I can only speculate that unable to hire their own attorney, not getting a response here back to 2007, nothing happening after the 2005, that at some point in time, he kind of gave up until for some reason, he decided to write you a letter.
It wasn't me. He wrote a letter. It got assigned to me through our aged case wheel. He and I didn't know each other until that was randomly assigned to me.
And was that letter put in the online?
Sure, we'll find it now. It's what got this whole train flowing.
Well, my memory is, and I may be confused, I thought you had told them to put it online.
It's the filing on July 25th, 2023.
Yeah, it's listed as docket entry number 1 because it was the first thing filed after 2008 when we actually then keep track of things numerically. So it's a nice letter written to, we're now 3 clerks later, and our clerks don't stay for just a couple months. Shay Alexander received the letter. It's on binder paper. You can see the torn edges. And he is wondering what's happening and lists some important dates. like a motion for new trial filed, and Carl Greenberg saying, I'm good, you don't need to find a different attorney. And then his words, Mr. Singleton's, after the August 16, 2005 date, there has been no progress in my case. True statement.
When was that letter filed, if I may ask?
Last year, July of last year.
So there was no action between July and then when you took action in December?
I don't know when I got it. This
Well,
is
I know you
when it was
took action
filed in
in,
the clerk's office.
I thought December, maybe November. So my memory, and I may be confusing this with another letter that you told the clerk's office that you need to put that online.
But you were appointed in December. But that's neither here nor there. I mean, there's some delay, there's additional delay, but we're talking fractional compared to the larger. I'll tell you, the last entry in the docket before that is from 2008. So there was the 2007 letter that I read to you, May 1, and then in May, a year later, Mr. Singleton actually didn't. Yeah, it's from Mr. Singleton to Paul Howard, trying to move his case forward into the docket in 2007.
Yeah, but I guess my response is twofold. One, if my memory is correct and that his letter was not put online until you directed the clerk to do it, that then also could explain why there were not other letters that were received but not put online.
I'm not saying there weren't other letters.
Okay.
There were clearly, there was outreach.
And two, again, my memory is also that at one point in time, I think he had communicated with Greenberg about filing a grievance against him, and I think Greenberg talked him out of it. Also, they tried to hire a different attorney. That didn't work. And then I think that then explains where he decided that he was going to try to do it himself, hopefully with the aid of those jailhouse lawyers.
Okay, well, I want to keep it to things that are in the record as opposed to your theories or something your client has told you in confidence. So let's get to then the prejudice piece. So reasons for delay, you've identified 3, and then defendant invoking his right. It clearly happened early on, and then the record doesn't show anything between 08 and 2023, but importantly, it shows that in 05, 06, 07, 08, Mr. Singleton was sending letters to the clerk, to the district attorney, saying, what can we do to move this forward? Prejudice. I agree with Mr. Armstrong that the Georgia case law is that the prejudice piece is a little different post-conviction than pre-trial. And so it needs to be more concrete. So if you could help me work through some of the things you mentioned. There are witnesses whose connection to the case I don't know, who are dead. That in some ways sounded like it would be a reason why it would be hard for the state to retry the case, but maybe they would have been able to shed some light that they certainly can't anymore. And then there was an attorney, another attorney who was deceased, and I hadn't seen his name connected with anything before.
Yeah, Ronald Armstrong, and his name came up through Odyssey or Tyler Host or one of those online were showing that he was an attorney on the case. No, I have not seen his actual involvement any which way. It still would have been nice to talk to him and see, especially with Greenberg's mental health issues, whether he remembers anything, talking to Greenberg about it, anything. And so far as passing away, I've already mentioned the trial counsel Gary Gashard passed away. Co-defendant and possible witness David Merez passed away, and witness Casmira, Casimiro Ybarra, Ybarra, also has passed away. Why is this important? And I think the state of Georgia says it's not just enough that people have died. It's not just enough that 1 million years have passed. It's not just enough that I guess anything happened. Where's your prejudice?
So I think what Dela Cruz says, the 21-year delay, is that the trial judge said that's not enough. And they said, we're not going to say he's wrong, that that's not enough. I don't know that the trial judge has said, wait a minute, in order to prosecute the amended motion for new trial, you ought to be able to cross-examine, direct examine, you'd be calling a witness, the trial attorney to say, why'd you do that? Why didn't you do that? And he is as unavailable as things can get. So if a judge were to say, a trial judge were to say, I find all this to constitute prejudice, we don't know that the Supreme Court would say that's not enough. But they said in Dela Cruz that the trial judge conclusion that that was not sufficient prejudice was, they affirmed that conclusion. I think, I know Dela Cruz didn't get relief, but it's Dela Cruz versus state, not state versus Dela Cruz. So assuming it was an appeal from the trial judge saying 21 years is a long time, but let's go forward.
And that gets back to, again, my submission to this court. This case does offer an opportunity for this court. We have that 21, 22, 23-year delay. We also have a 16-year-old juvenile. Yes, no longer 16. He eventually turned 18, 21, and just recently 40. And I would submit to the court that there's a valid argument so far as prejudice, not only because of the length of delay, but when you're talking about a 16-year-old juvenile. I can, go ahead, I'm sorry.
I have heard that. David Merez, you said was a co-defendant. Did he go to trial? What was his trajectory in this?
He, after Singleton, received a very good plea offer and took it.
Singleton, they were severed. They didn't
Yes.
go to trial together. So
Yep.
Singleton is convicted, gets the life sentence, and Merez pleads out. Did he testify at trial?
I don't think so. My memory is that he did not, and Mr. Armstrong.
He did not.
Okay, but he's unavailable now. Whatever you might learn from talking with him, speculative, we don't know what he had to say, but you'll never know.
But my point there is Waters was the leader of this group. He was the 18-year-old. And granted, there's not a whole lot of difference between 15 and 16 and 18, but there is a difference.
Merez was also younger?
Yes.
Okay.
And my argument to the court is that once Merez finds out that Waters is changing his testimony, he then may be also willing to testify as to what exactly happened. And I don't know because he's passed away.
Okay.
He would be a great witness if what I believe is correct.
He could corroborate Waters' second version of events to show that Waters is, this would be your argument, that Waters has now come to the truth. He's been changing his story because he feels bad for Singleton, or I can give him a freebie. I have a life sentence, so it's no sweat off my back to help this guy.
Yep.
How about this Casimiro Ibarra, Y-B-A-R-R-A?
He was a witness.
Meaning he rented the car to someone?
Well, he offered the kind of, and you see this often, the corroborating evidence that doesn't really say the person did it, but is something, okay, well, if that happened, then I guess maybe this makes sense that this then could have happened. And is this what he heard? 'Cause
He testified.
yes.
And is he someone who was consorting with Waters and crew, or he just was a bystander and said there was this car, I heard a door shut, I heard gunshot?
He was friends. And my memory is that he heard things that then were said afterwards.
Friend with the defendants.
Defendants.
Defendants,
Yeah.
yes.
And then he heard things that were said afterwards. You know, for example, one, Singleton didn't know that anybody had been killed. Didn't even know that people had actually been shot until afterwards.
Other than himself.
Yeah, I'm sorry. And then, and his initial statement to the police was not very true because he didn't even know anybody had been shot and killed. Once he found that out, he went to the police, gave another statement, and essentially true, but didn't name his co-defendants. And
Ibarra is dead also?
yes,
Not good to be associated with this group.
well, that's the interesting part about all of this. And I mentioned this to the court before.
Is that a bad sound?
I don't think anybody should be there right now.
Just a whole nother courtroom.
Oh,
I can say.
No, I think it was real loud, but we've got a whole nother courtroom over there. Okay. So as long as you're not worried,
No, I'm not
all
worried.
right, I mean, that door's locked, so.
We heard terrible sounds like that on one of the elevators today.
Okay. That's a county elevator.
It was scary. So anyway, involved in all of this was the person they called Miss Kathy. She was a very good support source for Leslie. And by that, she's part of the reason why he went to the police. Miraz is kind of involved in that group, heard things, said things. If you look at it one way, yeah, that kind of semi-corroborates. But again, he was not there. He didn't see what happened. So it's none of that. So I'd like to talk to Miraz, but he's passed, to find out what you said, how much of that is influenced by what Waters said or what you've heard otherwise. Those type of things that trial lawyers would ask. But again, he has passed. Anything I can move on, or any other questions about witnesses that have passed away?
Nope, that was it. Now I know who they are and their potential connection to anything.
So moving on then to Gashard. The question still is prejudice. And again, it's no secret to anyone in this courtroom who practices or has been a judge that strategy is the best answer you can give if you're alleged to be ineffective assistance. But there are things here that Gashard could not have used as trial strategy. Not objecting to an officer vouching for the credibility of this critical co-defendant state witness. Not cross-examining the ballistic, the DNA witnesses, or bringing in an expert to show that Singleton had already been in the process of exiting the vehicle.
So I think I can navigate the assessment of how Mr. Singleton's appellate rights are impacted by the death of his trial attorney. Because we're speculating now to say he couldn't say that's trial strategy. He could still say those words. You could say, well, why wouldn't you have done that? That's trial strategy. I decided being invisible was the best thing for my client. All right, I then have to decide, is that reasonable trial strategy? So I'm confident for every example you're going to give, Mr. Armstrong can say, here's why that could have been a reasonable trial strategy. But we can't have that debate because Mr. Gashard's not here to say, I messed up on that one. And I've had plenty of defense attorneys say, I fall on my sword on that one. I should have known better and I didn't do that. And then I have to figure out, well, what's the impact of that error, that ineffective assistance of counsel? But we'll never know what Mr. Gashard's self-assessment was, good, bad, or indifferent, because he can't be here. And that clearly has an impact on your ability to prosecute the motion for new trial. So you don't need to speculate what his answers would be.
Okay. The follow-up then on Greenberg. If Greenberg would have pursued those issues, again, Judge Downs would have granted a new trial. And that's in conjunction, when we.
How does his unavailability, Greenberg, alive but unavailable, prejudice Mr. Singleton now?
Same thing as with Gashard. I can't believe that he can say trial strategy or appellate strategy as to all these reasons why for not filing an amended motion for new trial, not talking to your client, not raising these issues. And again, you and I will talk all day about leading questions, but when a detective is vouching for the credibility of a witness, that's maybe not number one issue, but it's top five. And the other one's not cross-examining ballistic DNA witnesses when that will show your client was exiting, had been exiting the vehicle, and then following up on that, not requesting lesser included offenses or instruction on perjury or immunity, not requesting an abandon. That one I suspect both, Gashai would do trial strategy on. And I suspect that 3/4 of the judges in our state probably would say, yeah, okay, I can see why I didn't want to do that. But
Okay.
I can only wish I would have had Judge Downs.
All right, other forms of prejudice that Mr. Singleton is encountering because of this 21+ year delay.
And that gets back to, again, to Barker versus Wingle, where they talk about the interest being to prevent oppressive pretrial incarceration, to minimize anxiety and concern of the accused, to limit the possibility that the defense will be impaired. If a witness dies or disappears during a delay, the prejudice is obvious. I recognize, again, Georgia doesn't per se agree or has tweaked Wingle, but I still think when you're talking about a 16-year-old juvenile who has been incarcerated for so many years in an oppressive system that has received and has suffered anxiety and concern, and we have shown that the death of these people have caused prejudice, makes it very hard to convince most courts to grant a new trial. The other factor I wanted to go into was the missing records. And again, notwithstanding the efforts of the court and the defense, we don't have the actual court file. Likewise, I have been unable to get the trial court file for Mr. Gashard. I've been unable to get the appellate file
How
for.
would you do that? I'm not surprised. He's deceased. I don't know if his records are in a storage unit in Texas or he moved away from Georgia. How would you get his trial file? I guess in theory, it would go to Carl Greenberg. If Carl's doing his job, he'd say, Gary, I need your file to see what you did and didn't.
Again, he can't because of the mental health issues.
Okay.
What I did, and I've had success in the past, but you're right, it's not open and shut, is requesting the same from the Georgia Public Defender Council,
Your former employer.
my former employer. I've also requested the same from the Fulton County Public Defender's Office.
But
And
Mr. Gashard wasn't with that.
yes,
I believe he was with the Conflict Defender's Office, which is a separate entity
Right.
within the Fulton County system.
It sort of was. I don't know that we have, we don't really have a conflict defender anymore. I think maybe Ms. Hemingway is one of the last. My conflict defender is Euphemia Cabrera, and she gets cases through Mr. Luemba, who is paid by GPDC. So there may still be the Metro conflict defender, but it morphed into DeKalb and Fulton, and then it tracted, and it doesn't mean there's not a building somewhere that we have the Gashard files, but it's not quite as simple as reach out to Dennis Francis anymore. Okay.
but by reaching out to the Georgia Public Defender Council, by reaching out to the Fulton County Public Defender's Office, Public Defender's Office actually tried. Public Defender Council did not. But I would suspect either one would then have said, okay, we'll try this. And that didn't happen. So that tells me that we did try and that those files, at least according to Public Defender's Office, are lost, which apparently is not that unusual.
No, I'm not surprised. I didn't press it
I'm sorry.
because I thought it was insignificant. I just think that's another example of how life has become more complicated for you in pursuing this, is that you can't get the trial attorney's case file.
Well, it could have been helpful as to some of the issues I've raised. Was there a motion to suppress the statement? And that gets back to the next one with the.
Where's it just the post the note in the file saying this guy's guilty and that's his file? I'll tell you something too.
I take it you knew Mr. Greenberg. The Fulton County Clerk's Office doesn't have the file. Contacted juvenile because my client is sure that there was an SB 440 hearing in juvenile court. I have received no response back from them. So there is indication, and I've cited in my response, that there was an SB 440 hearing before the Fulton County Juvenile Court. Also,
those hearings aren't before the juvenile court. I shouldn't say, typically they're in front of a magistrate judge and not in front of a juvenile court judge. But there's a magistrate judge who hears those and says, yes, bind over or don't bind over. Where the file would go for that, I don't know. So you may have been knocking on the correct door, juvenile court, but I think the hearing is one that is kind of a superior court-ish hearing. But
And I don't know at what point, if that was right from the get-go or if that changed in the later 2000 years. That's also kind of what I'm seeing, is that's where it would have been. But again, in talking with my client, he's convinced that there was one in juvenile court. That's why we reached out to juvenile court to ask him if they had anything, not just that, but anything, and got no response. The record reflects that there, in the Fulton County Superior Court, there was a probable cause hearing, a Jackson Dental hearing. There was also a state motion in limine, and we have not been able to receive those transcripts. I even reached out to Judge Downs' court reporter, who's no longer.
around.
Yes.
Wow. This is why your investigator's bill is so high.
And why mine is waiting to be cut by the court. No luck there either. So again, not being able to access the court files, not being able to get the transcripts from what we see from the record we do have, that there were hearings, that is prejudice. Evidence that could support our motion or could help us or the court.
There are some transcripts here. I'm just seeing what they are. And there's defendant Mirez. His records will be easy to find. He was 18, Mirez, in 2000. I can't tell what the hearing, I'm not trying to delay things, I just was gonna get you another transcript. If we could, I can't. Just says proceedings, and then they're just talking. Mr. Singleton almost entered a plea. Looked like. Oh,
Mr. Waters entered a plea.
I know he did, but the last thing Judge Down said in this, let's go forward with the pleas for the 3 defendants. He clearly didn't enter a plea.
Can you have your office send me that transcript?
I will. Yeah. Yeah, they're all pretty short. Okay. We'll work on that. Make a note. Back to you.
Thank you. And as I close, I do want, I guess, to apologize to the state and also to the victim's family. You and I have known each other for a while, and sometimes when we banter, it's by no means meant to minimize the anxiety, what the victim's family has gone through.
No, this is, appreciate you flagging that, and everyone should know your focus is Mr. Singleton and what he's been working through. I'm sensitive to what everyone is going through. There was perceived closure insofar as a conviction brings closure to the deceased family. They presumably thought, well, it's over and done with, guilty verdict, and we didn't hear anything. I guess he had an appeal and that's all good. And he didn't. And so 20 plus years later, they are having to reopen the emotional scars and the wounds of what that family went through when their loved one was taken from them by Mr. Waters and his associates. So this is difficult for everyone. Hopefully the passage of time makes the sting a little less, but I think you're right to flag that, and I don't mean to minimize it in any way. But the issue before me isn't, was it a bad thing that Waters and crew shot and killed this man? unquestionably a bad thing. Is it also a bad thing for our system of justice that this person, that a jury found guilty, hasn't had his appeal in 20 years? And no one should want that either. So we've got a dilemma on top of a tragedy. And the court system lets everyone down that way. This victim's family as well. They're not the ones sitting in prison, but now this is back up in their face again. And they're probably wondering, why can't you guys do your job right? The jury said he was guilty. Why are we still talking about this case? That's a natural and a fair reaction, and it's not their fault.
And I guess that's my final point. It's not their fault. And it certainly must seem wrong that we are even here today. And when you talk about prejudice, under Wingo, we talk about prejudice so far as the defendant's ability to pursue his motion for new trial. But I also recognize that inherent in all of this is a prejudice to the victim's family. It's got to be very hard to have these things brought back up. It's got to be very hard to be there on Zoom, just as it is for my client to be there without being able to say, judge, this, that, whatever. And that's why I asked for the court off record, and I would indicate that my client, again, as we have indicated from day one, is remorseful for what happened. Anyone in this courtroom, if they were me, would say, judge, give us the new trial, period, end of story. My client's desire is to get out of prison. And by that, he is willing to accept as a possible resolution, one, if he is released on parole, and this would be both Fulton and Clayton County, then he would drop his amended motion for new trial. And I'm not talking about being released next year or who knows when. I'm talking ASAP. Two, as an alternative, he's willing to accept an alternative conviction for manslaughter so that there is still some conviction of record. Again, his goal is to get out of prison. Recognizing this court has no authority over the parole board. This court has no authority over Clayton County. A manslaughter conviction would not change what is there in Clayton County. It may help us, but it would not change it. Finally, if this is not acceptable to the victim, then he's willing and we will proceed forward with our amended motion for new trial. Thank you.
Thank you, Mr. Wood. Mr. Armstrong, we're focused on the 4 factors and you don't really need to say much about the first factor. But
Correct.
I'm happy to hear from you as to the others. Let me switch the cameras around. There you go. All right.
Yes, Your Honor. I would like to begin to address Mr. Hort's assertion that this court should follow Barker versus Wingo rather than Chapman versus Mansell. Beyond this court not being able to do that because the decisions of the Supreme Court of Georgia are binding on this court, that is an inappropriate thing to do. The Supreme Court of Georgia fashioned a rule for a context outside of the speedy trial context. The Sixth Amendment speedy trial right is what Barker versus Wingo comes from. He had his trial, it's over. That's not the issue. And if there had been a pretrial delay for somebody who had not been arrested or indicted that fell under due process, the defense would have to show a lot more of prejudice. They'd have to show that the state intentionally held off on indicting or arresting somebody to get a tactical advantage over them. They'd have to affirmatively prove that. And because that fell under due process, which is less specific than the Sixth Amendment. And so having a situation where the defense has to prove prejudice is completely consistent with regular federal interpretations of the U.S. Constitution. Number one, about the length of delay, I will note that just this year in Terry Harper versus State, which is 318 Georgia 185, the Supreme Court was reviewing a 19-year delay in that particular case. And they found...
In Georgia 185.
Yes, Your Honor.
Okay.
And I have encountered this issue when I was a defense attorney, and I've done it when I have been a prosecutor. I have not looked in the past couple months, but when I've had to address that, including in the Harper case, which I filed a response to last year, there has never been a case where the defense has successfully shown prejudice. It just has not happened in the state of Georgia. There's these claims that come up because unfortunately we have a long delay in some cases. And it is not the majority of my focus, but I'll go ahead and mention a few things about that delay and why it has happened in Fulton County and in other places in the state. Up until
You're now talking about reasons for delay. Or you're
yes,
still-
not to justify, but to explain.
Yep.
Up until the Owens cases and other things from the late 2010s, the basic approach to motions for new trial was that's the defendant's case. They're the ones in charge of bringing forward the ones they want. That's one thing. The state certainly in this case asked for it to be assigned to somebody else, and Carl Bringberg filed a response that said, I'm only raising the sufficiency of the evidence. I'm ready when the court is. And that was unfortunately the end of it. That is for people who've practiced appellate law in the state of Georgia for a long period of time. That is basically code for this is an Anders brief if I could have filed one, but the state of Georgia doesn't allow me to because there's nothing to get out of it. And so far, I've not seen anything that would suggest that Carl Bringberg was incorrect in that because I've not seen any issue here of possible merit. And so I wanted to mention that because we say a lot of things about people in the past, but them not being here to defend themselves, there were sensible reasons for those things. And one of the things that defense counsel, including myself, have delayed cases for is hoping that maybe they will find something. They will figure something out that's just not there, or the law will change in a way that advantages a defendant. So if you have nothing, waiting actually can benefit your client. As far as who bears the burden for the delays, I think that the defense obviously bears the burden near the front end of the case. Your Honor identified the
State defense, though, walk me through how I differentiate between defendant, Mr. Singleton, and defense, because I don't disagree with you that early on it would be Mr. Greenberg not moving the case forward. We don't have him here to say, I was doing the Armstrong shuffle where it's not a whole lot that's good. Why do I want to rush this? Because maybe 6 years in, it turns out that the lead detective gets prosecuted federally for lying, and we can go back and use that to suggest he was not a credible witness, or we learn more because we can get his internal affairs record. Someone have to fall in his lap. That is your interpretation of Mr. Greenberg's bare bones filing. I don't know that many of his filings were other than bare bones, so I don't know how to distinguish between what he filed in this case and maybe what he filed in other cases.
So it's to that, because that was something Mr. Hort mentioned about the original motion for new trial. Mr. Greenberg's original motion for new trial was actually much more detailed than the average motion for new trial.
Okay.
Basically,
And then he modified it to say, look, I'm ready to go forward. It's just sufficiency.
he responded to say that. He didn't amend it.
Okay.
But the Code of Georgia, the legislature, has actually given defense attorneys in the state of Georgia a template for how to file a motion for new trial to preserve those rights, and it's shorter than what Carl Greenberg wrote. It's literally in the code. There's nothing wrong or suggesting of a deficiency in an attorney performance when you file simply that bare bones document to preserve the issues.
Sure.
And so as far as the cause of the delay, Your Honor has no evidence to indicate currently before it that what was going on. And so the presumption is the defense is the defense.
Okay.
And so there's nothing that bleeds into the invocation of the right where you don't really have that beyond the simple filing of the motion for new trial and Mr. Greenberg's response that said, we're ready for a hearing whenever the court is. Now, the court is absolutely part of the state when you deal with that. However, that's not we want a hearing, we want a hearing now. The indication in the regular speedy trial determination depends on how you assert it and the vigor with which you assert it. That was never asserted here. The best that you have identified, as Your Honor did when going through the record just now, I had identified every filing in the state's response every filing that had been made prior to the court finding the case. And there's a really unintelligible document, but you've pointed out that it's addressed to Paul Howard. Whether it went to Paul Howard, I have to agree because I looked at it, there's a stamp on it. But it was asking for certain documents. It wasn't asking for a hearing. It wasn't saying, I want this hearing. So you really don't ever have an invocation of the right. And so to the extent the court weighs that issue, it's not one that should weigh heavily in favor of the defense or against the state.
How do we weigh the court system's inactivity on this?
So typically,
Certainly not, it doesn't land at the feet of the state, but that doesn't mean that it's neutral for the defendant. If his case isn't moving forward and there's nothing in the record about, oh, my docket was congested, I couldn't do this or that, just the court didn't do anything.
so I don't know how you would address that, because ordinarily when you have the court having other cases and that's basically the cause of the delay pre-trial, that is something that is weighed very benignly. You have a circumstance in which the state asked the court, let's move this along.
Yep.
And it didn't happen. And so at least as to that point, I would weigh that against the defense. At least as to the point where Carl Greenberg said, I'm ready when the court is, I would weigh that against that period of time against the defense. As far as prejudice, I'm going to have a lot of different points to make. The Clayton County case was about how Singleton got the gun, because he committed an armed robbery against somebody else in Clayton County to get the gun that was marked Fulton County Sheriff's Department. Michael Waters was a step in the chain, because Leslie Singleton, as his own testimony identified, gave Michael Waters that loaded gun after they left the home on the way to the drug dealer's house, at which they came across Sergeant Grigley and Miss Blaylock. He gave Michael Waters the gun. Michael Waters disposed of the gun and then later came back and got that gun and gave it to somebody who has the name of Jackie Brown. Officers went to the house of Jackie Brown and acquired the gun there. There's obvious relevance to his testimony just to establish that this was the same gun, but you do have Leslie Singleton's own statement establishing that at his trial in this case. And so,
Meaning Singleton testified in his murder trial, I gave Waters the gun.
correct.
Does he say, and I got it from an armed robbery, or he just said, I had this gun, I gave it to him?
I don't believe he addresses the armed robbery, and I think that Sheila Ross, who is the prosecutor in the case, was trying to avoid that.
Sure.
So when you see assertions about why was this officer going to this apartment complex in Clayton County late at night, all of that's irrelevant because that person didn't testify. Sheila Ross didn't care about that. It was essentially Leslie Singleton talking to Ibarra, talking to others, showing them the gun, showing Mike Waters the gun, and basically what he said he got them, and then basically him giving it to Michael Waters after they leave, which he again admits. He gave that loaded gun to Michael Waters after they left, knowing that Michael Waters' intention was to rob the drug dealer.
Michael Waters is serving a life sentence now?
Based on his guilty plea in this case, yes.
Okay, so he is serving a life sentence for being the shooter.
Correct.
In this case, okay.
He agreed to plead guilty in exchange for his testimony, and so he got a less sentence than he would possibly have been requested to get after a trial.
Sure, but it was a life sentence.
It was a life sentence.
And he's doing minimum 30 years for being the gunman in the case.
No.
No,
For offenses that took place before 2006, parole eligibility is after 14 years.
yeah,
So the reason that you've heard that Mr. Singleton has been eligible for parole and gone before the parole board twice at this point is because he's under the 14-year rule.
got it, okay. But his dossier in front of the parole board doesn't look so good because he has the Clayton case as well.
I imagine, but
Yeah,
that's speculation on my part.
same with me. Okay,
So you heard issues that are basically pure speculation on the defense's part about what these other witnesses could testify to. Ibarra, he made statements before trial and he testified at the trial. So basically thinking that he might have said something that was positive for Mr. Singleton is pure speculation. Merez, he had the right not to testify at the trial because he had not pled guilty and he'd not agreed to testify at the trial. So he had a Fifth Amendment right against that. Now, he also made pretrial statements, which have been in the record for 25 years almost. And so the statements that he made were in the discovery on page 170 of the discovery that was turned in September 2000. I can't read the date terribly well. Merez's statement to the police that was in discovery is remarkably bad for Mr. Singleton. It would not have behooved him. It's on 170 and 172 because there's a copied blank sheet between them. If the court wanted to see what the state would be able to impeach Merez with had he testified, it's bad for Mr. Singleton.
If Merez testified differently from what he told the police.
Correct.
If he was consistent with what he told the police, it's bad for Mr. Singleton.
Absolutely.
Okay.
So, Your Honor mentioned you wanted to ask if Mike Waters' expected new statement, because no evidence has been presented to the court yet. There's been a proffered affidavit, which could eventually get admitted if Mike Waters testifies here. That's what the defense has asserted is Mike Waters' statement. So even assuming that is in fact Mike Waters' statement and he would testify to that in this court, that statement is not good for Mr. Singleton. As I included in footnote 6 of the state's response.
Your response to your response to the second amended motion for new trial?
Correct. I've only filed one response to my knowledge.
Good. Me too. I just wasn't, that's my knowledge as well. But Mr. Hort had just filed something and I was
Correct.
shocked if you had already filed something to it. You're referring to the one big state's response so far.
Correct.
Okay.
And footnote 6 includes some of the information that is purportedly coming from Mike Waters now that would be material to show that his testimony at trial was false. That statement includes the following. Leslie got the female out of the car and she was frantic. That is consistent with the trial testimony. I told her we are not going to hurt anyone and just wanted the car. After we got the car, we'd leave and they would be fine. That calmed the woman down. Leslie rounded the front of the car and got into the driver's seat. That is consistent with what Leslie Singleton testified to at trial. When Leslie got into...
Where are you? I thought you said it was a footnote.
Footnote 6 on page 10. I apologize. I should have said page number instead. When Leslie got into the driver's seat, he said there was a problem because the car had standard transmission and he didn't know how to drive a stick.
Getting out of the driver's seat.
That is consistent with the testimony at trial. However, Mr. Singleton testified at trial that I think he testified that he was faking it because he didn't really want to do it. Because his defense was, I wasn't really have a meeting with minds of this. And so another thing that's at issue is abandonment is for somebody who is part of something, leaving that something. You're not required to have consistent.
We do have defendants who pose exhibits B and C, Waters' statement and the affidavit. Instead of just referring to footnotes, I can offer that and the court can have that.
We'll get to it. I'm just hearing from Mr. Armstrong right now about prejudice.
I didn't want to mislead the court as to footnotes.
Okay.
So the state is not agreeing that Mike Waters' testimony is coming in because until he testifies, we'll object to hearsay.
Okay.
This is what the defense has proffered as his statement. So even assuming that they get that in, this is what that statement would be.
This is.
Correct. I quoted from it.
Okay.
Now, Leslie Singleton didn't testify that the reason he didn't drive off was because he had problems with the stick. That's what other testimony was. He testified essentially that they hadn't had a meetings of the mind.
He's sort of backing out.
Correct. And one thing that it would be very hard for the jury to believe, I think, for a regular person to think that you were completely on board with everything until that moment. Because
You hand the guy the gun.
correct. Other than you are now afraid of something to your left. When you were in the driver's seat and you got in the driver's seat and you closed the driver's seat door, why are you going to eject yourself out of the passenger seat? That is not a reasonable thing to say that Gary Guichard could not not have failed to make this argument when his argument was a different defense where Leslie Singleton was just acting because he didn't know what better to do and he didn't actually have a meeting of the minds with Mike Waters. The evidence showed that that was incorrect, but that was the defense presented. And it would probably be a better defense than an abandonment defense. Now, Your Honor did mention the court would just be left with the idea of prejudice from a claim of ineffective assistance of counsel. That is incorrect because one of the things that the courts have said consistently is that the question is whether there is no attorney who could reasonably choose to fail to act or to act in the way that was not done. And so to give you an example, if I can find the correct page number. One of the claims that you've heard multiple times is about the bolstering issue. On page 22 and 23, the state responds to that in the state's response. One black letter part of law is whether to object during direct examination or instead rely on cross-examination falls within the ambit of reasonable trial strategy. Gary Guichard literally called back to that exact statement and said he wanted to go over with Waters that second statement. That was supposedly the truth, is the quotation mark that Gary Guichard says, which indicates pretty clearly that he is addressing that exact statement on direct in cross-examination. And then he did, in fact, cross-examine Mike Waters in that. Gary Guichard's cross-examination of Mike Waters, in case that you were wondering, considering there was an assertion that he didn't cross-examine the witnesses, he absolutely cross-examined witnesses when it made sense for the defense and Mike Waters in particular. One detail that I thought was phenomenal that goes against the idea that Gary Guichard just didn't talk to Singleton and they didn't communicate at all is there was an issue about whether Leslie Singleton provided the masks on the night in question or whether Mike Waters already had that and used them himself. That was really the only main difference that I could see in their testimony, other than Leslie Singleton saying that I didn't really agree. And Gary Guichard cross-examined Mike Waters on something that he could not have known to cross-examine him on, but for conversations with Leslie Singleton. He asked Mike Waters, has Leslie Singleton been in your house? Has he been in your bedroom? How many times has he been in your bedroom? On the wall in your bedroom, what is there? And Mike Waters had to admit masks and other things that could be used as a mask. That's good cross-examination. And that shows why you probably want to deal with cross-examination rather than anything else. The state believes that there was a Jackson-Deno hearing because of notations within Odyssey. And so that's the one transcript that Mr. Hort has identified that we believe should exist and believe does exist. It's my understanding that there's an issue with the physical file of this case, and that does concern me, because what happened when cases used to be filed is they would file a physical paper copy with the clerk's office and there'd be a physical file. At some point, the clerk started going electronic, and my experience has been when you see an older case that comes back up for relevance, you have to ask them to scan the documents into Odyssey, and they'll be scanned and added. There's a notation from February 2001, I believe it is, that indicates a January 31st hearing involving Singleton was submitted not long after the January 31st date. And that is the date that I understand the Jackson-Deno hearing was scheduled for. I believe that physical transcript is in the physical file. So we got to find the physical file. I strongly suggest getting Elizabeth Markowitz involved because she's very, very good at finding things.
We're working on that.
If it's about searching any kind of large room, I volunteer to do it in a t-shirt and shorts so they know I can't bring anything with me, because we do need that. However, even if we cannot find that, I would suggest in this particular case, Leslie Singleton's statement was presented at trial and people testified about the giving of it. The statement itself wasn't able to be played because of technology issues. So instead they read into the record a statement that he made on paper, which in addition to the recorded statement, they had somebody type out what he was saying and correct it if he could, sign his name at the bottom saying that this is truthful. And so in any kind of motion to suppress, the court can consider the testimony not only at the motion to suppress, but also at the trial. And so I think that there's sufficient information to know, to be able to address that, especially in a case like this where he testifies and testifies so closely to what the state's evidence is against him. And so that's one thing that I wanted to mention. I honestly have no idea who Ronald Armstrong is. I will mention that sometimes on Odyssey, there are notations about people who represented somebody very early on who never actually did anything. I'm not certain. I am dubious about the idea that ballistics can show that he was trying to exit to abandon the car at the time that he is shot in the car. He talked to Ibarra afterwards and said what happened, and Ibarra suggested his DNA might be in the car presciently. And so that's one of the reasons why he ultimately went to the police on his own. As far as the missing records, I don't know that there would be any transcript of an SB 440 hearing of any kind because it was almost a ministerial act because this was at the time within the exclusive jurisdiction of the Superior Court. It had to start here unless the district attorney declined it. So the only relevant detail at that hearing would be whether the DA declines or doesn't decline.
Because it was a murder prosecution, it was the DA's to send to juvenile as opposed to the DA's to pull from juvenile.
Correct. This is before there was a mental health evaluation or anything like that. That was made part of the law. This is before all of that. That was the exclusive jurisdiction of the Superior Court at the time. I don't believe that there was a probable cause hearing because there's none notated in Odyssey. I don't know why that was mentioned as being notated in Odyssey. This individual was indicted, I believe, less than a month after the act itself. And so typically that's too quick for a full-blown preliminary trial hearing. Either way, even if defendant was denied a preliminary hearing or if somebody had testified at that, their trial testimony proving to a jury beyond a reasonable doubt would basically negate any relevance that really had. I don't know what motion in limine hearing. There are Odyssey notations for hearings, and I can read them into the record unless the court would like to do that on its own. But essentially, I can't tell you that Odyssey is 100% perfect on notating hearings correctly. But I did not see anything that would necessarily be a motion in limine hearing on itself. This is a case, just ultimately speaking, this is a case of overwhelming evidence. You have the defendant's statements to others. You have the defendant's pre-event statements to others, showing them the gun that ultimately was the murder weapon. His testimony admitting that he gave the murder weapon to Mike Waters after they left with it, while knowing that it was Mike Waters' intention to commit a robbery, even though it was of the specific drug dealer. You have Leslie Singleton's testimony that when he gave it to Mr. Waters, it was loaded, that he saw Waters with masks with him, that they came across Grigley's and Blaylock's vehicle. His testimony was that he was present. He testified that Waters asked him if he wanted to rob them of their car, and that Singleton testified, "Nah, you got it," or "Nah, you got it, hot boy," to Mr. Waters. He admitted that he knew that Waters was robbing them. He admitted that he ran up to that ongoing robbery unbidden by Waters. Waters didn't call him over or say, "Come over here, I'm going to shoot you." He went up on his own. He admitted that. He admitted that he caught the cell phone that Waters tossed him during the robbery. He admitted that he got into the driver's seat of the vehicle after it was running because they made Miss Blaylock turn the car on. He admitted that he closed the driver's side door of that running vehicle. He admitted that Waters got into the passenger side seat about 15 seconds later, and that he, being Mr. Singleton, manipulated the gear shift. Although again, he testified that he was just making it look like he knew how to do it. He discussed leaving with Waters. He admitted that he was shot inside the car with Sergeant Grigley, and that they ultimately both got out on the passenger side and fled together. He admitted all of those things. Ibarra made pretrial statements, Merez made pretrial statements, Waters made pretrial statements, Singleton made pretrial statements. Singleton's DNA was found in the car, as Ibarra presciently assumed would happen. Singleton admitted that he had lied to Miss Kathy, the friend's mother, admitted that he'd lied to another friend, that he'd lied to the police and to the first responders when he called for help because he was shot. He admitted that he lied to the police even after he admitted he was present at the crime scene. He admitted to lying all of those times. And then in this court, the defense actually submitted more evidence that Leslie Singleton has admitted that he was there, that he was involved, and he did these things. When he was talking to the psychoanalyst who testified and admitted that Leslie Singleton knew that he was making an unprotected statement and admitted to all those things that were in the exhibit that were admitted last time that we had this hearing. The evidence is overwhelming. There are issues about the record and about that Jackson Deno transcript and about whatever else might be in the clerk's file that we can't see on Odyssey, because in addition to that Jackson Deno hearing, you have transcripts that are not correctly under what they're notated as being. So you have different dates under wrong dates already for other things. And I believe you have at least one duplicate in there. So it's a scanning issue more than anything. I do not deny that we have those issues in this case. And it is a case for which there has been a delay for which there's no good reason, 100%. But this is not an issue from which the court cannot discern the defendant's claims appropriately on the record and decide them against him or in his favor if they are able to show something that I'm just not aware of. And so as far as whether the pre-hearing delay in this case has prejudiced Mr. Singleton, I submit to the court that it has not.
Assume for a moment that this is not a good case for a sufficiency of the evidence argument. If we got to a ruling on the amended motion for new trial, how do I navigate an ineffective assistance claim? That Mr. Guichard was ineffective for doing A, B, C, D, E. You've answered some of them. Actually, he didn't object on direct. He cross-examined the witness and beat him about the head with the statement. So there are things you can glean from the record, which you, as you usually do, have done. But we don't ever get to hear from Mr. Guichard.
Correct. That is not a requirement. We had a trial here a few years ago where the defense attorney died 3 months after the trial, unfortunately. No opportunity to ever ask that person why they did things. And so you have two things that you have to draw from. The record, which shows what they did do, and the defense to establish what they could have done from what they didn't do. To call the witnesses that are uncalled, to submit the experts who were unobtained, and other things to show within the discovery and things of that nature, like for a mental health issue. If there was information in discovery from which a reasonable attorney would say, oh my God, I need to have this person evaluated, and we know that person was never evaluated because there's no request to have that. Or if we have testimony saying, I jumped up and down and told them that my son had mental health issues, things of that nature, to basically show what a reasonable attorney would know at the time and what a reasonable attorney would do. You can still have that evaluation. It's not as great, but the reason that we require defense counsel to at least attempt to have an attorney testify in a motion for new trial is because too often you have that Monday morning quarterbacking where y'all just, not y'all, like people question somebody about why did they do this thing, whereas they can offer a perfectly reasonable reason for doing it. That's essentially what it is. I have a colleague who many years ago, every time they read any motion for new trial would ask, why did this person act so unethical, talking about the prosecutor, the investigator, the defense attorney based on the allegation because it wasn't clear in the record. And my response was always like, there could be reasons for this. What are the other information in the case? That's essentially how the court is able to do it. Basically, 21 years, sometimes people are still alive, sometimes they aren't. 3 months, sometimes people are no longer alive.
How are you doing, Ms. Rivers?
I'm good. I just don't understand.
Okay, I'm sure he's got something to say. Do you need a break or are you good?
No, I'm good.
Okay, Mr. Hort.
Thank you, both of you. I do wonder if we're talking about the same case. The evidence. We are. The evidence was by no means overwhelming. And since Mr. Armstrong is going through the evidence under his impression. Let me go through the evidence that I have found through the transcripts.
Okay, before you rebut his evidentiary arguments, what is this helping me with in terms of the Barker v. Wingo factors, as opposed to it's just a riposte to something you don't like hearing from Mr. Armstrong?
Good question. Reason why, and I've been doing this for a while, 1978, harmless error. And judges tend to think, well, if the evidence was overwhelming, then everything else doesn't matter. And they sometimes get persuaded. And I don't mean to insult this court, but I've heard this court before say, well, the evidence against him is pretty conclusive. And it's not.
So it's healthy for us to engage on that. You're not gonna tell me he wasn't there. You're not gonna tell me he didn't get in the driver's seat. You're not gonna tell me he wasn't inside the victim's car when he got shot. But you are gonna tell me how, consistent with the law of party to a crime, which you pointed out early on, is the law in Georgia, this was anything other than a pretty strong case for the state.
Just like if something were to happen here, I don't think we should charge Ms. Rivers, even though she's here.
But merely present on the scene is different from I climbed into the driver's seat of the victim's car, absent testimony. You would have brought this up before. Waters pointed the gun at me, Singleton, and said, you get in that car and you drive it, or else. And
that's what I was going to kind of give you in my presentation here.
okay.
That this is not just a matter of committing a crime and then changing your mind. Or as Mr. Armstrong would say, overwhelming evidence that he was a party to the crime.
Okay.
So again, I know I've said this multiple times. We're talking about a 16-year-old kid. What did he do? There was no concerted plan to rob or kill anyone. Leslie's plan that night was to get some weed from a drug dealer they knew, sell it, give him back a certain amount, and keep a certain amount of the money so he could bond his mom out of jail. Waters' plan was to rob him because he had caught him and his daughter having sex, pulled a pistol on him, and told him to get away from his daughter.
Oh, the drug dealer.
The drug deal. And that's what this was all about. It wasn't about deputy 18.
And he had a daughter
No,
that the drug dealer was having sex with?
the drug dealer had a daughter that Waters was having sex with.
Oh,
Drug dealer pulls a pistol on Waters
got it.
and tells him to get away from my daughter.
Oh, and so now in revenge for that, you're breaking up my relationship, and how dare you pull a gun on me, I'm gonna rob you.
Well, I'm, if not do more. But again, that's Waters.
So they found the wrong guy.
What happened, and I'll tell you that next. Again, Waters had the bandanas and mask on a wall in his bedroom. He did get the gun from Singleton earlier, but not for the purposes of killing the deputy or even robbing the gun dealer. That's all Waters. On the walk to the drug dealer's house, it took longer than it should have. Waters, already mad, decided to take a car, and that's when the deputy gets involved. It was Waters alone who came up to the car with a gun, made them get out of the car, and then waving Leslie and the gun, telling him to come on. So you asked, did he point the gun at Leslie? Well, if you're a 16-year-old, I think you probably would have thought that. Leslie, who had just turned 16 4 months earlier, made the wrong choice, ran up to the back seat on the driver's side. Waters tossed the cell phone to him. That's what Mr. Armstrong said. Mr. Armstrong left out the remainder of that sentence. Leslie didn't want it and he threw it down.
As opposed to he didn't catch it and it hit the ground.
I'm going to guess if I throw anything to anybody in this courtroom, they're going to guess it without thinking. Then what do they do? Did they look and see what I have on my cell phone? Did they throw it down? Did they throw it across the car? What did they do? The initial reaction, I'm going to guess for everybody, if somebody throws something at you, you either knock it out of the way or you catch it. Waters told him to pull off. Leslie did not want to take the man's car and instead put it in neutral. Waters and Leslie started arguing.
When you're reading, this is your argument, or this is from
The transcript.
Waters's affidavit?
No, it's from the trial transcripts.
Oh, so this would be, Mr. Singleton testifying, I didn't want to drive away in the person's, I'm just wondering where you get this, Leslie didn't drive away. If this is just your perspective on it, you don't need to share that with me. But there's something in the record where Mr. Singleton either said, I didn't want to drive the car, so I didn't.
And I reference volume 3, pages 795-896.
Okay. That's like a 100-page site.
Unlike this former judge, I have no assistance.
Okay.
And I can certainly cut and paste if you want me to send that to you. So deputy jumps up, Leslie turns his back, running over Waters through the passenger side. Not initially knowing that he'd been shot by the deputy, he takes off running, stopping when he heard a bunch of rapid shots, but not knowing that Waters shot the deputy. Initially young, not knowing that the deputy or anyone had been killed, he gave a false statement that he was the victim of a robbery. But when he found out that Waters had killed the deputy, with the encouragement of his friend, he turned himself in. When he got to the police station, he told them essentially what happened, but used different names. So this is not overwhelming evidence. This is a 16-year-old kid that made some bad decisions, but then ended his involvement, not knowing what was going to happen and even what was happening. From everything I am seeing here, this case started in juvenile court. Leslie, I believe, and again, that's my belief, was arrested. And at that point in time, prior to any indictment, grand jury, whatever, and it started because he was a juvenile in juvenile court. And his belief is then that there was a SB 440 hearing in the juvenile court. And again, we're talking about 2001. I can't tell you, and the court knows much better than me as to when it came into place that juveniles were going to be charged as adults, but I assume this was still fairly on in the process. So our belief is that it did start in juvenile court and then was moved to the state court, superior court. But I guess, Mr. Armstrong and I disagree about the evidence, but that's not why we're here today. The question here today, more than anything else, is the prejudice. And yes, this court well knows that I will fight things tooth and nail. Mr. Armstrong seems to be okay with me presenting other cases where Gouchard and Greenberg did the same type of things. If that's the way it is, then that's the way it is. We have many, many other people where Gouchard falls asleep during the trial, doesn't try if he thinks the person's guilty. Greenberg doesn't do anything, goes to the movies in the afternoon. We've got some cases, and I again appreciate this court, where colleagues years and years later dismiss it because the defendant didn't do anything. Not trying to find out, well, where's his attorney? How about if we communicate with him? Or how about if somebody talk to the defendant and see why he didn't do anything? Just dismiss it because the defendant didn't do anything. And again, I appreciate this court. So my point is that the passing of Gouchard, the loss of the records, the mental inability of Greenberg to testify, that is prejudice. And yes, I will do everything I can to get around it. And I think I can convince the court, but then you've got to let me bring in all these other cases to show during this time frame, before and after, this is how Greenberg did things or did not do things, and the same with Gouchard.
How were you planning on working through the Waters situation? Was he a witness you were gonna call? You have a witness list.
Yes.
I say, he's someone you were gonna call.
Way back when, I thought he would be testifying at the next hearing.
Okay.
But then I don't believe we'll get through the witnesses today, so.
Okay.
My plan was, there's a number of witnesses today, and then next time would be Susan Wardell, who was the second chair. And then starting to go into intrinsic and extrinsic evidence.
who do you have for today? We're gonna take a quick break after you tell me that, just so Ms. Rivers can get fresh. We can only go till 5. If you've got people who are here today, if we can put a couple of them up. I'd really like to hear from Mr. Waters. We won't do that today, but I need to digest everything you all have shared with me, do a little more research, and then I may say, here's who I want to hear from next. And,
That's fine.
but who were you planning on?
So Ash Jossie is going to be our first witness.
Okay. And I know who he is. What is his connection to this case?
Try to get a spelling of what? J-O.
Joshi.
Yes, and Ash is A-S-H.
Yeah. Ms. Rivers knows who he is.
Okay. Mr. Armstrong, I believe our last hearing had said, what's going on here? Why is he saying the state did something they shouldn't do? So Ash was an assistant district attorney during the Paul Howard years, and he would be testifying as to what was expected of ADAs during that time frame. The favorite phrase is indict first, investigate second. So he would be testifying as to the Paul Howard years. And then also there was another case, Damian Braithwaite, Braithwaite,
He's on your list.
which took place around the same time frame as Mr. Singleton. He was one of the ADAs on that case, and he would be testifying as to that case. There's, in that case, alleged a co-defendant also testified against Mr. Braithwaite. And then he would be offering a little bit of testimony about Mr. Bouchard.
So Mr. Joshi would be saying, here's how the DA's office worked back then.
Right. And it goes,
And that's relevant to what I'm working through in what way?
it's not per se relevant as to today's issue, but it's relevant because Mr. Armstrong has raised that objection. And so my thought was
What objection?
that how dare you accuse Sheila Ross or anybody in the district attorney's office of doing anything improper? Where does that come from?
Oh, what is it that you've accused Ms. Ross of doing?
Physically bullying an individual into making a statement.
Physically? Come on, Mr. Armstrong.
You indicated the officers and Sheila Ross working together threatened physically to harm an individual to get to make a statement. Is that not the correct answer?
That is the correct answer. Your first one is not.
Okay, who's the witness?
I believe it's Mr. Waters.
Okay, so all the more reason we should chat with Mr. Waters, and see what he has to say about that. And then I think we would work backwards into, whether that means Ms. Ross needs to come in here or, one of the officers who, was allegedly intimidating to Mr. Waters. I'm not, I'll hear from Mr. Armstrong in a second, but unless Mr. Joshi knows specifically about what happened in this case, we're getting into some of the area that I've already told you I don't think is appropriate to get into. Like, hey, these kinds of things happen, so maybe it happened here. We don't work in maybes. It would be what happened here. And Mr. Waters may well have told you, hey, the only reason why I gave a statement was because, I'll just use the word coerced, because it was coerced. And you're certainly free to explore that coercion. If Mr. Joshi played a role in that coercion, let's have him come on in. But if he simply says, I know what happened in the office back then, and what you're describing is not inconsistent with things that had happened in the office, we don't need to make a record of that, because I'm not going to credit that as being proof that it happened in this case.
Well, my response is two or threefold. One, I have filed a motion for reconsideration.
Yeah.
I've not ruled on that yet. Two, 2001, the rules of evidence were different than they are today. Three, Mr. Joshi's testimony would be intrinsic evidence, something that would not then be covered per se by 404B.
Well, and my pushback is more relevance, because 5 people in the district attorney's office did something doesn't mean the 6th person did it. And if the 6th person is the one who's involved in this case, that's who we need to hear from.
The question that I would ask the court is the strength of Paul Howard. You only need to go back right before the election when he lost, and he indicted police officers without any type of investigation. My understanding, and I would expect it to be from this witnesses, is that was the rule in Paul Howard. You indict, and then we work things out later.
Okay, but I'm still not following. In a case like this, where your client's blood is in the car of the victim, what's the indication that there wasn't a whole lot of investigation in this case? Like what were the stones that you're gonna show me were left unturned by a sloppy, too quick to pull the indictment triggered DA's office? What you pointed out is that there is an alternate interpretation of the events, which is that even though he gave the man the gun that was used in theory to go rob a drug dealer, but ended up being to kill a police officer, that peripheral involvement's not enough to think about him as a suspect. And when that's further linked to his blood in the victim's car, how dare the DA's office pursue an indictment party to a crime murder?
I guess I would ask in return, how many times, and I was an assistant prosecutor for a while in Michigan, how many times did you work out a deal with the shooter and then testify against somebody else and then get a lesser sentence? That doesn't happen. And the fact that it did happen, that should be a very big red flag right here.
What was the deal he got?
Life served 14.
Oh, right. Well, he got life, but it's life in the 14-year era.
The promise was 14 years. And that's part of the law enforcement. And I don't know if Ms. Ross did that or if she just stood there or sat there kind of like Ash did with the Damian Braithwaite case. I'm not accusing him or the ADAs of doing anything wrong per se, but there was this pressure, this force that was put on by law enforcement, deals that were worked out in return for convicting somebody.
Okay. Who else do you have here besides Mr. Joshi?
I also have Leslie's sister, but she's been coming to all of the hearings. So yes, it would be an inconvenience to her not to testify today, but she'll be back for further hearings.
Okay.
And then I also got
what's she going to be talking about?
Leslie during those years.
As in he was a good kid or he had a difficult life? I mean, what's the relevance to, again, motion for new trial and what we're working through?
The relevance is to support the claim that it was not his plan. He was not part of this overwhelming evidence. He made mistakes as a kid did. And then to show the effects on his life, part of which Mr. Armstrong referenced that's in that forensic report of the who and why Leslie was at the age of 16. So again, it's not per se addressed to today's issue.
No, I understand. Same with Mr. Joshi, but I'm trying to see how it's relevant to, if we just set aside today's issue and we're back to good old fashioned motion for new trial.
And Mr. League is also here. And Mr. Mathis was asked, but he's not present. He would be by Zoom, assuming he hasn't.
I'm here.
Okay.
I'm here.
Okay.
He was Mr. Waters'
here.
attorney.
Got it.
He was Mr. Waters' attorney.
Mr. Waters' attorney. Okay. So my thought is we take a quick break and we hear from Mr. Mathis of the people you've described.
Ken, Ash asked that I put him on ASAP, but
I bet he did. I'm not inclined to hear his testimony based on what you proffered.
and I would want to give an offer proof as to what the questions would be from him.
Okay, but we've got Mr. Mathis now, so do you need a quick break, Ms. Rivers? I don't mean to force a break on you.
Yeah.
Okay, we'll take a quick break. When we come back, if you want to make a brief offer of proof, you can excuse Mr. Joshi. And then you can make the offer of proof for the questions you were going to ask. But we've got Mr. Mathis hanging in there. It sounds like Mr. Singleton's relative will be back anyway. Not so sure. I'm going to hear from her either, because I don't see how it's relevant to what we need to work through. Make an offer of proof on that. Mr. Mathis, on the other hand, depending on what he's willing to answer in terms of lawyer-client privilege, could be, I'm seeing lots of potential connections.
And he may also open the door where you may want to reflect your decision on Mr. Jossi.
Could be to tell us about what happened in other cases, but maybe not. All right. Don't go too far. When Ms. Rivers comes back, we're gonna get going.
The reason I was raising my hand is because I also need to come for breaks.
Go for it.
Let's talk again.
So we need one of these in the courtroom.
What are you pointing to?
These podiums right here.
Is the microphone connected?
No, I'm saying for me to write stuff.
Oh, you like having that space there?
Yeah.
Hey, if you want to get one in our courtroom, I just want speakers that are a little louder. Not this loud, but louder than what we've got. Actually, what I'm liking the most still is that speaker we had in 5C.
5C, I'm still on the hunt for that.
Yeah, good.
Excuse me, Judge. Two questions. Clearly, substantive question. Can then his sister leave?
Yes,
Okay. And two, would you mind saying hi to his sister's daughter?
I would not mind.
She's trying to decide if she should be a police officer, fire department, and then she came up with the possibility of being a judge.
How old is the daughter?
I'm gonna guess 7, 8, maybe.
Okay,
I could bring her in just a quick second.
that's fine. We're on break. After all that, you drop it on the ground? Jeez.
Got nervous.
Hello,
Hi.
how are you?
Good. Been waiting in the back.
What's your name?
My name is Zoe.
Zoe? My name's Robert. How old are you?
7.
7. And where do you live? In what city?
The city. My city is Hampton.
Hampton, Georgia. I know where that is. All right.
You homeschool, they don't even know. I'm so used to being at home.
So you're thinking about maybe being a fireman or a policeman or maybe a judge? That's exciting. What makes you think about those things as opposed to a president or a doctor or an astronaut?
Well, police officer and firefighter is basically helping other people, and I want to be helpful and be relatable.
That's great. Well, that's a great focus to have. Doctors help people too. But you gotta deal with blood if you don't like that.
I don't want to do surgery or anything.
Yeah, well, it's good you know early on the things you want, don't want. That's good. Well, judges get to help people too. They have to work through complicated problems. And sometimes when there are two sides, one side leaves happy and the other side's not so happy because the answer is good for, if there's a dispute about who's, you have what's one of the favorite things you like to play with?
Dolls.
Dolls, all right. So what's your favorite doll?
Barbie doll.
Barbie doll. So there's one Barbie doll, you say it's yours, what's the name of one of your friends?
Lily.
Lily. And Lily says, no, that's my Barbie doll. And you both have this good claim that, no, this is Zoe's Barbie doll, no, it's Lily's Barbie doll. And so you bring it to a judge who might be, maybe your mom is the judge there. Your mom has to decide, one person's gonna leave happy because there's only one Barbie doll, and she's gonna say, I know this is Zoe's, because look, she put her initials on the back. Zoe's happy, Lily's not gonna be so happy, because she really thought it was her Barbie doll. Maybe she lost hers, it was a mistake, and she thought your doll was her doll. So sometimes when the judge makes the decision, one person's super happy, the other one not so much. But every once in a while, you gotta make a decision, and everyone's okay. So, but you do get to help people. But you have to go to school for a while to be a judge. Not just what grade you're in now, but a while longer.
What do you think about that?
I think that I want to be a judge.
All right. Well, that's great. So always use more judges. That was easy. It's a little safer, firemen, they're going in and it's a burning house and they have to rescue someone, and that's super important. That's dangerous. And sometimes police officers, the bad guys, they're big and strong and dangerous sometimes, and that can be a little scary. I have a police officer who protects me all day long, so I'm safe. That's Deputy Gordon. And I get to be way up there, so that's a little easier. But they're all good jobs. I'm glad you want to help other people. Plenty of kids your age say, I want to be the next Beyonce and make $1 million. And that would be kind of fun, but there are other ways to give back as well. How long have you been sitting here today? Long time? You're a very patient little girl. It's nice meeting you. All right. Good luck with everything.
Thank you.
All right, we've got about 30 minutes. Do you think we can get through Mr. Mathis at that time?
Yes.
So he doesn't have to come back? Great, okay. Well, let's get back on the record to make sure we've still got Mr. Singleton. There he is. In what looks like some kind of digital operating room. So we're back on the record, State versus Singleton, is Mr. Mathis Dine Out Deliveries?
Yes, John, and I don't know why it's listed that way, but that's me.
All right, can you turn your camera on?
Yeah, I'm actually driving, so yeah, this gives
Well, yeah, we need you.
me about 6.
Okay, well, I'll leave
I'm
that.
pulling over.
Oh, good choice. You pull over just for the conversation, that'd be good.
Yes, sir. Yes, sir. Okay, I'm pulling to this parking lot right now, sir. Can you hear me well?
Yes, very well. You've got a good lawyer projection voice.
All right, I'm pulling to the gas station now, sir.
Great.
Hey. Okay, I'm ready.
Be stationary, excellent. Okay, Deputy Gordon's gonna swear you in. He's coming up to a screen. Let me add him. All the screens here. we go.
You raise your right hand. Do you swear or affirm that the testimony you'll give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Lower your hand. State and spell your name for the record.
Tony Mathis, Mathis.
Mr. Mathis, without disclosing any confidential attorney-client information, what was your involvement in the Singleton case?
I represented Michael Waters. I never met Mr. Singleton.
So you then would have been Mr. Waters' attorney.
Yes, sir.
During this time frame, how long have you been practicing as a criminal lawyer?
It's a while back, maybe 10 years, I guess. I'm guessing. I was a former prosecutor. I had went to private practice a couple of years after I met Michael. When I met Michael, so
Were you a prosecutor in the Fulton County office?
DeKalb.
Yeah, okay. But as a defense attorney, then you would have tried cases in Fulton County?
Yeah.
And again, not asking you to guess or speculate, is there anything you can tell us about the Paul Howard years during that time frame?
Objection, Your Honor, relevance.
Sustained. Tell me, Mr. Mathis, were you retained by Mr. Waters and his family, or were you appointed?
I was retained, Your Honor.
Thank you.
And is it correct that he then did enter into a plea agreement?
Yeah, actually, I listened to that. There actually was no agreement. What happened was, if I can just cut to the chase on this part, Mike's mom came out to office, hired me. I went and spoke to Mike at the jail, spoke to him a couple of times. And he was remorseful from the very start. The very first conversation I had with him was remorseful.
Objection, Your Honor.
Hold on one second.
Because Michael Waters hasn't waived his attorney-client privilege, I'm going to object on hearsay grounds to what Mike Waters said.
Okay.
I said it was remorseful.
Okay, hold on. You don't get to respond to the objection. Take off your lawyer hat. You're the witness. You're the witness. I'll see what Mr. Hort has to say about that.
Yes, you can, I believe, tell us your impression versus, seeing him, facial gestures, but not based on what he said.
Okay, and that's what he was doing so far, but I think Mr. Armstrong may have been lodging this objection just as a preventative way, but we've got a double issue. There's the privilege concern too, and I'm confident Mr. Mathis is particularly focused on that. So I'm going to accept his testimony as appropriate, that from the get-go, Mr. Waters was remorseful.
Now, we were talking about, or I was asking you about the plea agreement. What can you tell us?
That's what I'm getting to. There was no agreement. Me and Miss Ross never discussed any of that. The first time me and Michael stepped into court, he jumped up, we pled guilty. The judge didn't even know what's going to happen. The officer's daughter was in the courtroom and apologized to her, but there was never a discussion between me and Miss Ross on any of that. When in the discussions with Mr. Waters, the information that he was given, if I'm trying to word this right, was at that time, life was 14. You can be eligible for parole at 14 years back then. We didn't discuss that, but he immediately pled guilty. So if any discussion between Miss Ross and some detectives happened to get him to testify, I was not there. I was not there.
Do I correctly understand that he did not plead guilty to everything?
He pled guilty to everything. We was in court 5 minutes before he stood and pled guilty. Soon the judge came out and announced his name, we stepped, he's pleading guilty. It took Miss Ross by surprise.
So neither Miss Ross or yourself said anything about any type of plea agreement?
No, and that's the point I'm trying to make. If there was a discussion about with Mr. Waters by Miss Ross and the detectives, I was not present, and it shouldn't have happened because we literally pled out within 5 minutes of walking in the courtroom. That's how remorseful he was by what happened. He was that remorseful. He didn't even want to try a defense.
So you're not aware then of any plea agreement so far as immunity or agreeing to testify or anything of that nature?
None of them discussions happened with my presence.
So any discussion
I should have been there, but I wasn't. No one told me that happened.
Were you told about any discussions
No.
with,
None. I ain't know anything about Clayton County. I ain't know anything about testifying in Fulton. None of that.
were you told about the date that he was going to be testifying on this day in Fulton
Not that I can
County?
recall.
What
Not that I
about,
can recall.
what about Clayton County?
I ain't know anything about Clayton at all.
Testify, Clay.
He did not.
He was called as a witness, didn't testify, and then was held in contempt. Because he
That's
didn't-
right, that's what you said. But by then, I mean, Mr. Mathis, I don't know how we would say representation continued.
He had not been sentenced yet.
He had not been sentenced yet.
Right.
Oh.
Is that
What-
correct, Mr. Mathis? He was-
This a while back. I'm trying to remember when his sentence actually occurred. It's been a while. I don't remember that. I'm sorry, I don't remember that part.
At any rate, you did not receive notice about him testifying or when, or in Fulton County or Clayton County.
No, not that I recall any of that.
And so far as you know, there was no plea agreement involving him testifying or receiving any favorable treatment or anything.
None was worked out with me.
And I assume then you would have objected if he
Yeah.
was being called as a witness when there was no agreement in regards to his testimony?
Yeah, I would have counseled him on that. I definitely would have counseled him on that.
So I take it then you were not even present during the Singleton trial,
No,
and that would be neither in Fulton County or in Clayton County.
no, sir. No, not that I recall any of that. No,
Did you have any contact with Mr. Singleton's attorney, Gary Gashard?
no.
Did you even know him during this trial time?
Mr. Burchard, I think I heard his name, but it's been just, courthouse, send people to
Okay.
courthouses. Nothing like that.
And what about Kyle Greenberg?
Never heard of him.
Have you read Waters' letter and affidavit about him lying at the trial?
I have not had any contact with Mike since over 20 years.
Okay, but I'm asking, we sent it
No.
to you. Did you read the letter or the affidavit from Waters about lying at the trial?
Oh, yeah, I read that. Yeah, we sent it to me.
Any relevant?
I don't know anything about it 'cause I wasn't there. I don't know anything about it.
Did you ever receive any follow-up paper or recording so far as interviews involving Waters, law enforcement, and the ADA?
No, like I said, I didn't know Mr. Watts was even talking to them.
That's all I have, Your Honor.
Mr. Armstrong, any questions for Mr. Mathis?
Yes, Mr. Mathis, you testified that at a hearing where the judge and the prosecutor did not know that Mr. Waters was going to plead guilty, you announced that he would be pleading guilty to all counts of the indictment. Is that correct?
Yes, sir.
Okay. If the record reflects that the court decided to postpone the guilty plea after that hearing, would you have any reason to contest that indication within the transcript?
No, I mean, it's 20 years ago. No.
Okay. If there's a court transcript dated November 28th, 2000, that indicates that that's the date on which you had the guilty plea hearing between you, Miss then Finley, now Ross, and the court, would you have any reason to contest that?
I said it again. I didn't hear this, sir. I apologize.
If the court records indicate that you had the guilty plea for Mr. Waters on November 28th, 2000 at a separate hearing away from the co-defendants, would you have any reason to contest that?
No. If that what the
Okay.
record says, no.
Okay. If I could just have a moment, Your Honor. I'm going to read you a paragraph and ask if your memory is inconsistent with this paragraph being stated at a plea of guilty hearing for Mr. Waters.
May I
This is
also
a
have a copy?
paragraph from what?
It is a paragraph from the court's transcript that was filed on December 1st, 2000. I don't believe that it is currently in its correct place within the transcripts, but it's under another proceeding. It is the guilty plea hearing for Mike Waters on November 28th, 2000.
Okay.
It is page 7, line 22, and it goes into page 8.
I would also like to have a copy of that if I can.
Absolutely. And that the state would request that your sentencing be, I can't give you a copy of it at this moment.
Yeah,
I'll get you, there are 3 transcripts that are dated December 1, 2000. that
Here.
I just saw, and so I'm gonna try to email those to you.
I will print it to PDF and pause, and
it's just hard for me to know whether he's reading everything or what else was said without having that in front of me right now.
Okay.
I guess since the court has indicated there's certain things I cannot do, I would ask the same thing.
is it the Hotmail address, Mr. Hort?
Yes.
And there will actually be a second one, so give me a second. Or I guess a third one. The guilty plea is listed as Mike Waters' transcript. I realize that's redundant since there's 3 transcripts that I'll have mentioned. There will also be Mike Waters' sentencing will be the one that's from April that we'll talk about in a few minutes. And I want to make sure I get the right one.
Are you sending all 3 of them?
I'm going to send all 3 of the ones that I'm referring to and telling you how I'm referring to them.
So would it be possible to have it on one of the screens so Mr. Mathis can see it as well as me?
I will join the Zoom after I press send. So the 3 transcripts that you'll be receiving is Mike Waters' announcement, if I've saved them all correctly. Mike Waters' transcript, which is the guilty plea hearing, and Mike Waters' sentencing, which is from April of the next year after his testimony at trial.
My objection is it's not going to do me a whole lot of good waiting until I get back to home or the office to read it.
Share screen, so it'll be up on everyone's screen.
Okay, thank you.
Where are you heading in Mississippi, Mr. Mathis?
Jackson, Your Honor.
All right.
It's a more fun place than Jackson, Georgia.
Well, not a lot going on in Jackson, Mississippi either, I'll tell you the truth.
It is not letting me come up to the Zoom. If somebody could email me the, oh, there it goes. Okay. I'm reading from page. My computer's on mute, so I don't know what's happening.
Hold on. I'll try.
Okay, Mr. Mathis, can you hear me?
Yes, sir.
Okay, I'm going to read you a paragraph and I want to ask you the following question. If the record indicates that this was part of Mr. Waters' plea hearing before Judge Downs, would you have any reason to contest it? I'll
Nope.
begin the quote now. And that the state would request that your sentencing be postponed until after the trial of your 2 remaining co-defendants, and that pursuant to this plea, that you give truthful testimony if called by either side, either the state or the defense, and the remaining trials of your co-defendants. Do you understand that? Would you have any reason to contest whether that was part of Mr. Waters' guilty plea?
No.
Okay. Now I'm going to the sentencing transcript from April of that year.
I'm sorry, do we have a date for that first transcript?
I do. It is on the front cover of that. It's hard for me to move around with share screen on. That was from November 28th, 2000. As I had mentioned previously, the next preceding transcript is from April 16th, 2001. And my search function is off. But Mr. Mathis, do you recall that Mr. Waters was sentenced after his trial testimony because that was part of his plea?
It wasn't, I don't recall it being part of his plea. I remember when we announced he's pleading guilty, it was more so the judge wanted to postpone the sentencing. From my recollection back then, it's been a while. But
Okay.
there was never any formal discussion with me and Ms. Ross. Nothing like
Now,
that.
by formal discussion, you mean there was no discussion of him pleading guilty before the announcement of his guilty plea, correct?
True.
Okay. I'm going to read you a paragraph from the transcript and ask if you contest whether you would have said this at Mr. Waters' sentencing in April of 2001. Your Honor, if you recall when we were present when my client put in his plea, he did express an apology. I think he was very sincere in his apology to the court and to the victim's family. He has cooperated fully with the state and basically upheld his part of the bargain. We'd ask the court to accept the negotiated recommendation, Your Honor. If the record reflects you having said that, Mr. Mathis, would you have any reason to contest that?
No.
And you recall when you first announced he was pleading guilty, you were announcing guilty to all counts of the indictment, correct?
Yes.
If he ultimately only pled guilty to 2 counts of the indictment, would that jog your memory about there being some more negotiations beyond that point?
No, it wouldn't jog my memory over 20 years ago, but if that's what happened, that's what happened.
Thank you very much, Mr. Mathis. No further questions.
Any redirect?
Yes, so,
Hold on one sec. Can you take down the share screen?
Oh, do you want any part of the screen? Oh,
that's fine, thank you.
okay, I'll stop sharing.
Thank you. All right.
The transcript we just looked at from November, would that have been the second time that you met with the court so far as the plea, or was that the first time? That's not a very clear question. There it talks about him pleading only to specific counts. Your memory was that he was initially going to plead to everything, and I'm wondering if that then took place at an earlier date.
There's one more transcript that you're getting that is the one that Mr. Mathis referred to. And I don't know the date. It'll be on the first page of that transcript, but that's the one I was reading that ends with that statement from Judge Downs of, oh, we'll take pleas at another date.
Okay.
I didn't read that whole transcript, but I encourage you to read it because that would be, if it were made public, as in on the record, Mr. Mathis would have represented my client wants to plead guilty.
Does that sound correct, though, Mr. Mathis?
That sounds correct, yeah.
Okay. So initially, your client was going to plead to everything. The judge then adjourned it to another date, and at that time, the state then offered X counts, plus also life and served 10 years, so to speak. Does that sound right?
Yeah.
And then does it sound correctly that at sentencing, the judge actually gave him 14 instead of the 10?
Yeah.
Now, does that change anything you've said so far as whether you were part of any discussions with the state law enforcement, Mr. Waters, with regards to him testifying?
Not that I can recall. I don't remember at all sitting down with, when they interview your client, you're normally there. You know, you're invited to the interview with the detectives and everything like that. That never happened. That never happened. That part never happened. Now, I'm trying to remember, it was 20 years ago, like I said, but in terms of his testimony, again, I don't recall me sitting down with them while he was being prepped to testify, any of that kind of stuff.
No other questions?
Okay. Mr. Mathis, thank you so much for your time. Drive safely to Jackson, Mississippi.
Thank you, Your Honor.
All right, bye-bye. All right, we got about 10 minutes before we need to stop. Anything else you want to present? Obviously, we're going to need another session. I'll provide some guidance as to, why don't we do this? You've got your witness list. I've got your witness list. I'd like to know the purpose of each witness so I could save you some scheduling time. If we wouldn't be hearing from a witness because he or she is going to say, this is what life was like in the DA's office at that time. Or in another case, not this one, this terrible thing happened. Or good thing happened.
Yes, Your Honor. Also, we talked earlier about me being allowed to present an offer of proof as to Mr. Jossi.
Sure. Why don't you do that while it's fresh? Unless that's going to take 15 minutes because we don't have 15 minutes.
As Judge Adams has said, she appreciates my ability to say it and get it out and be done.
Okay.
Okay, so for Mr. Jossi, the offer of proof is I was going to ask him whether he was an ADA in the Fulton County during the Paul Howard years, and he was. Then he went back to being a criminal defense attorney. I was going to ask him about the Paul Howard error. I expected his testimony would be that the greater cause was always his reelection. He would indict more cases to get more funding. His motto was to indict first, investigate second. I was going to ask him about the relationship between Howard and his assistant district attorneys. I expected Jossi to testify that he would place significant pressure on his attorneys. Many were young ADAs doing major criminal murder trials, and also then the pressure to win. I was also going to ask him about the Damian Braithwaite case. This is a case that took place during the same time frame as Singleton. He was the assistant district attorney on the case. It was a murder case with juvenile defendants. It was one of the first cases he was involved in as second chair. Originally, there were 5 people arrested. I was going to ask him about Detective Strozer, that's Strozier. I expected his testimony to be that Detective Strozer was the lead detective. He was not afraid to impose his will. His interview technique was to put the defendants in cells next to each other, go back and forth, get statements implicating each other, and then work out a deal for testimony. I was going to ask him whether it was a common practice during the Paul Howard years to work out deals with co-defendants. And I would expect that he would answer in the affirmative. And I would ask him, was there any effort to make sure you were getting the most culpable persons? And I expect that he would have answered that it didn't matter who was the possibly more culpable defendant. I would ask him about the Braithwaite case. His memory was that of the defendants, this was the last case of 5 to go to trial. At that junction, it was mostly following the script, this being the last case to go to trial. The pretrial work, investigation, witness identification was essentially done. It was mostly getting up to speed and confirming expected witness testimony. I would ask him whether the ADAs and Detective Strozer met with James Ward and whether he's seen the statement from James Ward that they did meet with him. I would ask him if he remembers how old Braithwaite was when the murder took place. I expect his testimony to be that he was 15 years old at the time of the offense, had finished the 8th grade. I would have asked him what was the purpose of the meeting. The idea to be ensure that his testimony would be consistent with what he initially told the police and that it would be consistent with his testimony at the earlier trial. I would ask him whether it was possible that his statement or testimony would have been replayed for him, and I would expect he would have said that was possible. I would ask him what the deal with James Ward was in return for his testimony, and if necessary, to refresh his recollection with the plea transcript for Ward, that instead of life and or death, the 15-year-old juvenile, now 18-year-old co-defendant would testify in the murder trials and receive a sentence of 10 years to serve 2 commuted time served. And then, of course, what would happen if he changed his testimony? He would have been told that if he didn't want to spend his life in prison, if he ever wanted to go home, he couldn't change his testimony. I would have asked him if at the time of the Braithwaite trial, the testimony probably would have been set as to each witness and expected affirmative response. I would have asked him what if Ward expressed any reluctance to testify in the Braithwaite case. I expected his answer would be same thing. He would have been told if he didn't want to spend the rest of his life in prison, this was not an option. I would have asked him if Ward did testify at the trial and expected he would have said that Ward testified against Mr. Braithwaite, saying his involvement was minimal and Braithwaite's involvement was substantial. Then I would have asked him about the statement from Ward that he, not Braithwaite, was the shooter and the pressure put on him to testify and what to say. And I expected that he would have said that there's nothing in his statement that is absolutely and completely false. Some details may be what he believed, what maybe he was led to believe. Again, the comparison being with the Singleton case. I would ask him about Gary Gashard during this time frame. He said he knew Gary very well and considered him a friend. He was the attorney, the trial attorney for Mr. Braithwaite. I would ask him about the Braithwaite case, and there were times I expect him to say that he would look over during the trial and see that Gashard's eyes were closed, still sitting up, and that his client had to wake him up. I asked him about other cases during this time frame where Gashard represented a co-defendant. I expect he would have said there were two trials with him, a murder case in 1999 and another in 2000. Both times he was sleeping during the trial. I would ask whether this was common knowledge amongst the attorneys and judges, and he would have said, I expect people talked. If the judges looked at the lawyers or jurors looked at lawyers, they would have seen it. And that, in essence, would have been the crux of my testimony from Mr. Jassy.
All right. Well, I am comfortable in excluding it as being about a different case and conduct of an attorney connected with this case in a different case. Tell me why Robert Ponder is on your witness list.
He and many other defendants were represented either by Gashard or Greenberg and had similar ineffective assistance of counsel issues.
Okay. Most of the witnesses on the witness list are in state custody, and I don't recognize them. I recognize Mr. Waters, and that's about it. Are people like Melvin Smith and Antonio Porter and Cephas Wells. These are all people you'd call to explore with them their experience with Gashard or Greenberg or both?
Yes. One of them, Mr. Braithwaite, also was in jail at the same time as Mr. Waters. So then he would also have some direct testimony as to Singleton.
What would his non-hearsay direct testimony be about Singleton?
Related to the pressure by law enforcement on Mr. Waters.
Monique Davis was the young lady who was here with her daughter.
Yes.
Priest Fulcher.
She was, I believe, an attorney on the Michael Lewis case. It's another juvenile with Gashard that eventually was released from prison after it came out that was an alibi witness Gashard didn't call.
I know who Carl Greenberg is. And then Dr. Tucker already testified? That's the doctor from before?
Yes.
Okay, and I know you're an investigator, and I know who Ms. Wardell is. Okay, that is helpful.
I do have more information on Ponder if you wish.
I know who he is. I was wondering why you knew who he was.
Yes. He was sentenced on September 3 of 2004. On April 2005, the attorney for Mr. Ponder filed a motion for appointment of substitute counsel. On June 6, 2005, Carl Greenberg entered an appearance on behalf of the defendant. On July 20, 2021, the defendant filed a motion for appointment of counsel and a motion for out-of-time appeal. On August 6, the state filed a response to a motion for out-of-time appeal. The online Fulton County records list no action thereafter by the trial court as to either the motion for new trial, the motion for out-of-time appeal, or the motion for appointment of counsel.
Okay.
And I do have information as to any other possible cases if you're interested.
Thank you. Mr. Armstrong, My thought is that I'm gonna read more. Oh, did you have, Mr. Hort, you had I don't remember if they were letters or numbers, exhibit 1 and 2 or A and B that were Waters' affidavit and something. I couldn't find that in my stack of stuff. Is that because you haven't tendered it yet? Or there's so much stuff, I just couldn't find it?
No, per the court's directive, Mr. Waters and I talked with regards to exhibits, and he agreed to 2 exhibits, but not those 2 and many other ones.
He
Okay,
meant to say Mr. Armstrong. My objection is to hearsay because the affidavit is hearsay. There's one statement that's not an affidavit that they are saying is his, but it has no date, signature, or anything else like that on it.
Okay.
So once he testifies and says that that's his document, then my hearsay objection will go away.
Assuming he is going to testify, if the court wants to see him now, if it's at all related to this prejudice question.
I'm gonna wanna meet Mr. Waters
Fair enough.
virtually. I think that's what we'll do next, not today, but when we can reconvene is get Mr. Waters. Do you have any sense that he will answer questions?
He was very cooperative with my investigator. He's the one that wrote the letter. It wasn't anybody making him do anything, so I would hope so.
Just, you told me that he apparently gets threatened all the time in order to make him talk. I just wanna make sure he'll speak freely this time.
Let's hope that GDC is not doing that.
Okay. All right. That's my thought, but I need to process a lot of what you all shared with me today, that when we reconvene next, hopefully soon, it's with Mr. Waters as a witness. Mr. Armstrong.
There's just one thing that I don't think Mr. Hort said it to be misleading or anything like that. But Michael Lewis was paroled. It wasn't that his conviction got overturned. And so when Mr. Hort said he was released after something came out, he was paroled. He's the person who Elaine Brown wrote the book, The Condemnation of Little B, about. And so his release on parole was in the news. And so I just wanted to mention that because I'll forget that before next time.
Okay,
And I'm
we
sorry,
aren't gonna spend a lot more time in litigating this motion for new trial about other cases, whether they were Mr. Gishard's cases or Mr. Greenberg or Ash Joshi's. We're gonna stay focused on what happened and didn't happen in this case, and what that means for a motion for new trial. So this witness list will be a lot shorter in the end in terms of who we call, but we'll start with Mr. Waters and see how much we have to push beyond that. I think Ms. Wardell, hearing from her is appropriate. Not so sure about Ms. Davis. It sounds like she comes anyway, so she's always welcome to be here. And certainly your investigator, but that may be where we sort things out. We do need to wrap up. The folks at Coffee have been super accommodating by staying late. Mr. Singleton raised his hand. Do you have a question, sir?
No question. I'll wait for my time to speak. I just want to say appreciate that, and that's it.
Okay, Mr. Armstrong, anything else before we wrap up?
Only the request for the clerk's office to continue the search for the physical file.
That's been put in.
Okay.
Mr. Hort, anything else?
Yes, sir. There were 2 exhibits that the state did agree to be admitted. Since we have 2 minutes, I would offer Defendant's Exhibit J, which is the Fulton County Police Department statement of Darren Bell for its possible effect on Mr. Gishard and his actions or inactions.
Who is that person?
It was part of the discovery. So to the extent that they're saying discovery had an effect on Mr. Gishard, I'm not agreeing to the truth of the matter asserted, but that this was information that Mr. Gishard had before him.
Mr. Bell, someone connected to this case.
I do not recall how at this point in time, but with that understanding that
It's not a different Gishard case, his client in a different case.
Well,
to the effect that it had on Mr. Gishard, it's my understanding that the 2 exhibits that I agreed to, I remember saying that to one of them. It's because oftentimes when there's an ineffective assistance of counsel claim and somebody says like, do you recognize this document? It's not for the truth of the matter asserted. It's because that was part of discovery. And
If
that,
it was part of discovery, it's good. I'll take it. That's J. And what's the other one?
well, I would like to have it offered pursuant to the agreement by Mr. Armstrong for its possible effect on Mr. Gishard and his actions or inactions.
Okay, that's J.
That's J.
Okay, so there were two, so there's
Yes,
not.
the other one
letter.
is O. It's the letter from Dr. Chatham, Chatham, Emory Generic Psychiatry, to explain why Mr. Greenberg is unable to testify.
I'll take both those, J and O. Thank you. Thank you, Coffee Correctional, for staying late. Appreciate it. Hope you get OT.
You're so welcome. Y'all have a great day.
All right, you too.
Thank you.
Bye-bye.
And we would ask that the court consider J with regards to the prejudice factor as to whether Mr. Gishard should have used this as a red flag to check out what actually happened in Clayton County.
Okay, thank you. I'm going to end the